Test.
Yeah, you know, I'm searching for conversationalists.
Test.
Test 1 2. Testing. Test 1 2. Test. Check. Test.
Again, welcome back to the Big Horn Symposium, Day 2. Glad to have so many people in attendance, as was the case yesterday. I'm going to keep my introductory remarks this morning pretty short and sweet. Yesterday focused primarily, not exclusively, but primarily on the history of the Bighorn adjudication and its counterpart, general stream adjudications across the American West over the past 30, 40 years. In contrast, today we'll focus primarily on the future, what comes next. Specifically, our morning will consist of 2 panels that have this prospective, future-looking focus. An initial panel will address what comes next in this particular river basin after the signing of the final decree this past Friday, September 5th. Dr. Anne McKinnon will be the moderator for this, what we've called Intrastate Prospective panel. We'll then have a short break, and afterward we'll have a second panel examining what role general stream adjudications will play within Western management, water management regionally in the future. And yours truly will moderate that panel. I know if you're not bothered by me by now, you will be by the end of that second panel. Without further ado, though, I'd like to begin the initial prospective interstate panel by introducing the moderator. Again, Dr. Anne McKinnon. Anne wears a lot of hats. Her education is bicoastal and international, I guess you'd say. She holds a bachelor's degree from an institution back east by the name of Harvard. She earned her JD from Berkeley and subsequently earned her doctorate from Humboldt University in natural resources economics. Her professional experience is incredibly broad-based. We're very fortunate to have had her as a committee member and as a member of the program, as a moderator here. She was the editor-in-chief of the Casper Star-Tribune for many years, so she has been a journalist. She's also a retired member of the Wyoming Bar, so that is, she's also been an attorney. She served on the Wyoming Water Development Commission for 8 years. She's currently an adjunct professor at UW's Haub School, so she is an educator, an academic. And finally, she's a consultant in public discussion of natural resource policy. That consulting role is the last hat that she wears. Again, we've been very fortunate to have her on the steering committee. She's been instrumental both in terms of the shaping of this panel and the shaping of the program as a whole. So please join me in welcoming Dr. Anne McKinnon. You got it to work?
Give it to them.
Okay.
Thank you, Jason. That was very nice. I should say that when I was the editor of the Star Tribune, I was in charge of that cartoonist who used to cartoon Jeff on a daily basis. And Jeff and I maintained our friendship throughout all that. What we're going to try to do this morning is take up the theme that was at the end of the morning panel yesterday about the need for communication. This is not a courtroom or a negotiating room, so it should be a place where people can talk without wondering whether what they say is going to be brought up against them in the next court hearing. And so we're going to try to really have a conversation. I'm going to start with our panelists, but after we get through some basic stuff, I'm going to try to bring you all in. I know some of you, and I may even call upon you and say, I bet you have an idea about that. But I also hope that you'll raise your hands. And I may, at some point, have to cut people off and so we can move ahead and get us through as many of the discussion items that the panelists and I have discussed. But I hope we can make it a conversation. We have 2 hours. First, I'll introduce our panelists. On my far left is John Anevski, who is the Water Resources Supervisor for the Bureau of Indian Affairs in Billings, and has been here, he came for the whole event. Next, we have Lyle Myler, who's the Deputy Area Manager for the Wyoming Area Office of the Bureau of Reclamation. That means he's based in Casper, but his operations cover here things on the Wind Bighorn all the way up to the Buffalo Bill Dam, and then Pathfinder and Seminole, and all the way to the Nebraska border. Then next to me here is Amy Cordalis, who's an attorney and a member of the Yurok tribe, and she came all the way from the Northwest. That's a Northwest fishing tribe. You've heard some about the Northwest issues, to give us something of an outsider's perspective on some of these issues. To my right is Pat Tyrrell, the Wyoming State Engineer, whom you heard from yesterday. And next to him is Baptiste Weed, who's the Deputy Tribal Water Engineer. The Tribal Water Engineer, Mitch Cottonar, couldn't come because he got called to Washington to testify. And Baptiste generously stepped in at pretty much the last minute, but he's extremely knowledgeable, so we're lucky to have him. And on the far right is Sara Robison, who was the liaison for the Wyoming Governor's Office to the Eastern Shoshone tribe, and is now in the Fremont County Attorney's Office. I wanted to start by reading a couple of quotes from works that were done by a couple of our conference speakers, both by Susan Williams and by John Thorson. The first is from a 1988 paper by Susan, but I think you'll feel it's still relevant. And the second is from a book that John Thorson co-authored called Negotiating Tribal Water Rights from 2005. And it's actually from David Getches, the late David Getches at the University of Colorado, who wrote the introduction to that book. I think they both speak to the Wind River situation. The first, from Susan, she described the history of policy towards the tribes in this country and ended up concluding that this is, quote, a time when great diplomacy and cooperation between states and tribes is critical to the protection of natural resources, the environment, and the interest of citizens on and near the reservations. And the 2005 from David Getches, practicality and justice are not easy to find where the irresistible force of absolute legal rights of tribes meets the apparently immovable object of a century of established non-Indian water uses. Yesterday, John Thorson mentioned that some of the concern at the beginning of all the tribal adjudication flurries in the 70s was that tribes would end up with big awards of paper rights that got them nowhere. And he said that that hasn't been the case with many of the settlements. But on Wind River, I think most people could agree that's really still the case. Half of the award is still a paper right. So a good deal of this discussion is inevitably about, if we're going to talk about the future, is there a way to make any of those paper rights wet for the tribes? So we're going to start. I've asked the panelists to we discussed these questions in advance, to be ready to talk about a variety of questions. We don't have individual presentations by each of them. So the first question I wanted to ask was whether users or potential users of water in this basin feel that the river is currently being managed optimally to serve the widest array of the desired uses. And we have a mic on each table. Mic on each table, and I think they're both live. Does that look live? Okay. So I'd just like to see who would like to jump in on that, of any of you. And you all need to speak at some point. Baptiste.
Yeah, I'd like to go back to the question if it's optimally used. Currently, the way it's being operated, it's mainly for ag within the what we see as being used. as far as tribal uses, I think we have a lot more uses we feel we're entitled to. Basically, just because it's back to a federal, it's a federal right. We put a lot of emphasis on in-stream flow, wildlife, aesthetics, things down that line. We see uses in the river, especially the Boysen. When you get to Boysen, we feel that's tribal water moving through the for electricity and stuff. I think in the future, I think we need to talk about that. We see probable dams we'd like built on the river. But I'm getting kind of ahead of myself talking on you know, how it's optimally used. I think it's optimally used as it is.
You think it is?
I think it is, as far as ag uses. I think as it gets back to what we would like to see as far as storage, the uses, the transfer of water and stuff, the way it's currently being used, we see some wrongs that we'd like right. We see the drying up of the river. We just see that there could be more management in that area that would that gets back to the tribes of what we'd like done in the Big Wind. Big Wind is probably the biggest contestant of water usage or water management at this point.
Thank you. So
yeah.
it optimally used for ag, but you mentioned another number of other uses that you think it should also go to, I think.
Yeah, we have, under our tribal water code, we have 15 beneficial uses, and ag is one of them. And we have uses that go to in-stream flow, domestic use, hydroelectric power, even aesthetics, if that's so willed within our board, within our water code. And we feel that, you know, those are interests that the tribal members would, you know, that do have. You know, that's been put into the water code as a mechanism for that.
So who else would like to comment? Great, Lyle. Yeah, with the green light, I think it's on. Here, take this. No, thank you.
Thanks for the introduction, Anne. I appreciate the opportunity to be here at the symposium and have the opportunity to at least represent the Bureau of Reclamation here. I wanted to give some additional background and kind of set the stage for those of you that might not have much experience with the Bureau of Reclamation or the history of reclamation. Reclamation came on the scene back in the 1900s. There was an act by Congress, the Reclamation Act of 1902, which gave birth to the Reclamation Service at that time. Now we go by the Bureau of Reclamation, which essentially provided authorization for the Secretary of Interior to go out, study, examine, look at sites, and develop irrigation works. Through the years, that act has been amended and authorizations have changed. So essentially, Reclamation has a framework of authority that we work with under, and that direction comes through Congress of the United States. In addition to that, that authorization directs Reclamation to work within state water law. So we are, when Reclamation came on the scene and developed some of the storage projects and irrigation facilities, we sought water rights through the respective states. And for example, Anne mentioned a couple of projects. Bull Lake Dam and Reservoir is a project that was constructed by the Bureau of Reclamation. Pilot Butte, which is an off-stream reservoir off the Wyoming Canal, which was also a reclamation facility. And then the Boysen Dam and Reservoir is a reclamation facility. And those are all permitted by this through Reclamation, through the state of Wyoming water law. So I'm in the situation where I'm actually a water user in the state of Wyoming, and we have the right to store water under a permit by the state. Then Reclamation, what Reclamation did was then is once we had the facilities in place, we would enter into a contract with an irrigation entity such as here in the Wind River Basin, the irrigation entity that we have a contract with for Bull Lake and Pilot Butte storage is the Midville Irrigation District. So, and under that contract, the district pays a portion of the original construction costs of those facilities. And then in addition to that, Midville Irrigation District has also been transferred. We transferred the responsibility to the district to maintain those facilities, the dams and the canal facility. Reclamation performs inspections to make sure that those facilities are maintained accordingly and that the public interest in those facilities are maintained in good standing order. One of the, what I'm trying to lay out here is that there's a framework of obligations that Reclamation has when we undertake any of these projects and in the operation and maintenance of those, and the operation of those projects. Specifically, with regard to the question, whether or not the river is being optimally managed, Reclamation's role in the management of that is basically to store water and deliver that water to our contract or the project beneficiaries. With regard to the quantifications of the awards, which has been accomplished under the Bighorn adjudication, that management or the process is meeting Reclamation's, I guess, needs to store and deliver that water to meet our obligations and responsibilities. So from our standpoint, the management of the river is working. Now, that's not to say there isn't potential for other discussions, but the management is working.
Anne?
Thank you.
I'm right here. May I respond? Good morning. It's good to see everyone here this morning. I hope your trip was well. I see Gary here and Bat here. I am besides being a tribal member, I'm an Eastern Shoshone tribal member. I've lived here on this reservation my entire life. My family has been here since before it was a reservation. I am an irrigator, rancher, and a farmer on the Ray Canal system. And so, with that being said, the water and its use and its relationship to us as tribal people carries a much different significance. And we talked yesterday about when you look at water and start talking about it, especially when the judges and the water masters and those people who are administrating these adjudications, they are looking at it from eyes that are very different from my eyes. Because if you look on the front of your program, the very top of those mountains within the boundaries of the reservation that was established for the Eastern Shoshone back in the 1800s are the headwaters of everything of that water that runs through the state of Wyoming. So is that personal to me as a Shoshone woman? Yes, it is. Because we're talking about it being sacred. We're talking about that water being a part of our ceremonies, a part of our daily life, a part of my great-grandparents' daily lives. And so that's what we're trying to hold on to while we're trying to learn how to play the game. And thank goodness we've had people like Miss Williams, Mr. Schumacher, Baldwin and Crocker, different individuals who have come forward to help us fight those battles as a tribe. Is it being used optimally now? It's not. And that was part of the trip for looking at Ray Canal. That system, when it was built, wasn't built to work to begin with. And that did come from the federal government. And that's reality for tribes. Not just this tribe, not just the Shoshone tribe, but for the tribes in Montana, for the tribes out in the Northwest, for any of the tribes that have irrigation. Because now they tell us it's $25 to $50 million to fix our irrigation system. I irrigate at the very end of Ray Canal. I don't think you were able to go up there yesterday, or maybe had to turn around. But all those lands there are lands that we irrigate, that are either allotted lands or tribal lands. And all we get to do with that is irrigate. But yet, my grandmother or my relatives that live out on Trout Creek, over on Sage Creek, where they need it for fishing, where we need it to revitalize and nurture the willows that we use in our ceremonies, it's not always there. And so, as Bat stated, there are all those uses in our water code, but we're not able to address all of them. We're not able to take care of them and manage them. Just like Mr. Valdez, my colleague on the water board, talks to us all the time, because he was in fish and wildlife for so long, about taking care of our fish, which we're not able to do at times. And so it's a matter of who you are, how you're looking at it, and your reality. Because my reality is not like your reality.
Well, let me, good morning again. And by the way, yesterday when we started, I was noting the rain, and now it has turned to snow, but I probably didn't say enough of a thank you both to the College of Law for this fine collection of folks and topics that we have here today on the Wind River, but to the tribes as well for the wonderful casino and this venue, which seems to be just about perfect for the talks that we're having. So thank you, and it's a pleasure to be here. When you look at the question that Anne has posed, I thought it appropriate for people representing water users to speak first, because to the extent changes come forward under a system of water laws and awards and administrative procedures, they've got to be driven by the user community. And that is because those of us who are administrators look at what's on the books, and we need to help divide the water to those users with rights for the purposes on those permits, whether it's storage or irrigation or municipal or in-stream flow. So it's difficult for an administrator to speak up and talk about whether a system is being run optimally or could be run differently, when in fact I represent or will be working with any number of users who could have very differing opinions about a river like the Wind River or the Bighorn River. What we do in this part of the basin can affect what happens to right holders down below Boise even, and so to some extent they are a part of the conversation on how we manage a big river system like this and respect the tribal awards, and even as we can possibly work toward that additional flexibility that the tribes certainly have vocalized this morning. And I think Sara was very eloquent when she said, your eyes may not see what my eyes see. I think those are great words, because we can look around this room today and there may be any number of different sets of eyes that can read back over the law of the river and come to different conclusions. In fact, I've been in conversations over the last 13 years where that's pretty evident. So the solution, if you want to manage a river differently from the way it is currently managed, is I think you've got to bring all the users into the room and say, how can we together increase flexibility on the one hand without injury on the other hand? Because we do have a fabric of water rights that have grown up in this river basin, and we are connected as closely to yellowtail as anything, because it gets what we don't use up here. So water is managed as a system in a basin like this. It's a system in the North Platte, it's a system in the Tongue and the Powder, it's a system on the Green and the Colorado. So how do we get all the varied interest into a room and say, what do we have, how can we share it? Let me, and get to an answer where we reach consensus. Here's an example. It's a smaller example, but it's one that worked. In the North Platte, we had an old abandoned beautiful canyon between Pathfinder Dam and Alcova Reservoir, Fremont Canyon. For decades, that was a dry creek bed because all the water from Pathfinder went to Alcova or beyond by pipes and canals, and Fremont Canyon flowed no water. A few years ago, the Bureau, the Game and Fish, flycasters out of Casper, the districts got together and figured out a way to move, I think it's 75 CFS, and maybe more at other times, down that canyon and have created a marvelous fishery. I've been there, and some of those fish you almost can't land, but if you can get to them. But that was done without any contact at all with water administration. It was done under existing permits, under existing contracts, with the existing plumbing, and it works. It was a win-win. What we have to work to do here is identify how to do something similar in this basin, and reach where more people can feel that the way the river is run is optimal.
Thank you, Pat. And John?
Sure. Good morning. As a representative of the BIA, you know, the BIA has a wide variety of responsibilities with tribes. You know, trust resources, there's fisheries issues, there's all sorts of things. My focus is on the water, but more on as the administrator of the irrigation projects. And so you know, optimally on the streams, I'm hearing, I kind of agree with a lot of the comments we've heard. A lot of times I've seen, especially on the Little Wind, we end up drying out the river a lot. But then we do have to provide domestic water flows for ETD and other towns downstream. But we have been working with the Tribal Water Board and the Tribal Water Engineer's Office to try to, you know, leave as much water in the streams as we can. But so I can say, yeah, I don't think the streams or the systems work optimally, and I think there's a lot of work that needs to be done. And going along with what Pat says, I think if we work together and try to figure out some ways to make it more optimal for all the water, all the different uses, I think it'd be really good.
Thank you.
Aikui Neknau Amy Cordalis, Nuwak Rekwa, Numetewa, Waklao. Good morning, everyone. My name is Amy Cordalis. I'm a member of the Yurok tribe. I'm also an attorney, and I've worked on Indian water rights issues for several years now, and I'm really happy to be here today, and I want to thank Anne and Jason and the tribes and everyone else for having me here, and I've learned so much over the last couple days. The tour was just incredible, even though I was so cold. So mostly what I'm going to talk about today is my experience on the Klamath River in Northern California, mostly as a tribal member, and then I'll insert my knowledge as an attorney as well throughout my remarks today. But where I wanted to start was just to share a little bit about my tribe's experience in relation to water rights and our fisheries. So the Yurok tribe is located in Northern California. Our reservation straddles the Klamath River, a mile on either side of the river, up 20 miles from the mouth of the river. The mouth of the river is about 20 miles south of the Oregon-California border, so we're really, really north. And the Klamath River is, and I'm not sure if it still is, but it once was, the third largest salmon producing river in the entire Northwest. So we have, you know, this amazing salmon river, and we are salmon people to the bone, to the core, and that's just what we've always done, and we're lucky to not have been removed from our Aboriginal territory, so we continue our fishing lifestyle. And the tribe works really hard and has dedicated most of its financial resources to developing good science for the river and for our fisheries. And what's happened in recent years is that at the top of the river, which is actually on the Oregon border, or over in Oregon, in southern Oregon, you have a huge irrigation community. The Bureau of Reclamation, similar to here, set up a reclamation project in the early 1900s. And then as you go down the river, you have three tribes, the Karuk, the Hupa, and then the Yurok right there at the mouth. And I think it was right around between, like, starting in the 30s and then ending in the 50s, there were 6 different dams that were built on that river, and none of them had fish ladders. So you can see the problem sort of coming together, right? You've got 6 dams, you've got this huge, amazing salmon run, and we had several salmon runs. There was salmon in the river for 9 months out of the year, but there were no fish ladders in these dams. And what happens when fish can't get to spawn, then they die and they don't, you know, recreate themselves or spawn, and then that's it. And then on top of that, you had irrigators at the top of the river who were, you know, using pesticides and whatnot to grow their crops, and then also diverting a lot of water out of the river. And so after, you know, 50 or so years of this type of setup, the river was so incredibly depleted. It just was bad. Most of our salmon were gone. The salmon actually at the top of the river for the Klamath tribes, and I forgot to mention this, that in that irrigation community over in Oregon, there is the Klamath tribes, and they used to be fishing people too. By the turn of, I think it was like 1970s, the fish totally disappeared from there. So this people who once were, you know, these great salmon fishermen no longer were able to salmon because the salmon were just gone. So all of this sort of came to be in sort of came to a front in 2 different situations. The first was that the dams, of course, required licenses from the FERC Commission, and those were expiring. And then, in addition to that, what happened was in 2002, we experienced the largest fish kill in American history. What happened was, it's estimated between 70,000 and 110,000 salmon died, all within the boundaries of the Yurok Reservation. And as a tribal member, and I was working for tribal fisheries when this happened, this was like experiencing what I imagine the slaughtering of the buffalo was like for your people and for the Sioux people. Except for this was happening in 2002. You know, and how could that kind of an environmental catastrophe occur in this day and age? And what it was it was entirely man-made. There were political decisions that were made which caused an excessive amount of water to be diverted out of the river for irrigation at the top of the river, and as a result, the water flows at the bottom of the river were so low that a bacteria got into the gills of the fish, and they just died. And so it was man-made. And those 2 experiences got everybody together, and what I'm going to talk about today a little bit is what we've done since that time in the past 12 years and the creative solutions that we and those folks there as a community have used in order to try to fix the river. And I'm going to talk about that in the way to say that it is huge that you guys all have decrees here. I mean, that is incredible. And if we had decrees on the Klamath River, my tribe does not have a decreed right. Maybe the fish kill would have never happened. So I think it's good that you have those protections in place. Yet the question that I think we should all be considering is, what does the basin look like after 1 or 2 generations of water administration under the decree? What does it look like? And does it look like, is the result something that you all are happy with? And if it's not, then that's where we need to start thinking about these creative solutions to make the basin what you folks want. And that should come from the people. And I think it seems to me that there's consensus in this room that, you know, it's got to come from the people. It can't be the lawyers, it can't be the technicians, it has to come from the water users. And so I hope today that I can provide some examples of what we've done on the Klamath River to try to make the basin there look more like what we want it to look like. Thank you.
Thank you, Amy. So we're going to move in, and I'll start dragging you guys into this conversation. But we're going to move into, this was better, thank you. I'll start bringing you into the conversation, but we're going to move into a question about, well, so what are the challenges and constraints to achieving a more optimal use of water in this basin? We're going to look at legal challenges, what would the law allow? Political challenges, what are the relationships and motivating factors? Who has power, where's the incentive? And we're also going to look at knowledge-based questions. Is there enough shared knowledge of the situation that people can really have effective conversation? So to start with the legal questions, would the law allow better optimal use of the kinds of things that really every panelist has mentioned, of maybe some different uses? Would the law allow that under the decree? And you've heard that the Bighorn 3, after the in-stream flow issue was, is almost unreadable because of 5 different opinions. So what the law allows is an interesting question. But I hope each of you, or as much as you want to, would contribute to what you think the law could allow, what look like constraints might allow what. And this, we have a lot of issues to discuss this morning, so we don't want legal treatises, but as much as you can, give a sense of what you think might be there that possible under the law. You want this?
I'll just sort of start that discussion off. In my position on the Tribal Water Board, what I have noticed, and I've only been on that board for 2 years, is that the majority of the time there is discussion. The tribe is not at the table. And when you have one major party who is not at that table to discuss their asset, then you can't move forward. And in talking with the Bureau of Reclamation, we've had a couple of those meetings, more so this past year than we've had in the past. And one of the questions that arose regarding the Pilot Butte facility was, why was Midville Irrigation contacted to rehab and run that project, and why were the tribes, even though that facility is within the boundaries on our water system, in the Crowheart Pavilion, Muddy Ridge area, why were the tribes never contacted? That the Bureau of Rec was looking at giving that project up. And that's, for me as a tribal member and as a person who sits in a position on the water board, really as a water administrator, why were we not called? The federal government knows, and I'm including all federal agencies and the Bureau of Indian Affairs, that the tribes have a huge interest out in that northeast corner of the reservation. And lands that were returned back to the tribe after the 1905 Surplus Act, we are wanting to develop, but yet the discussion between the Bureau of Reclamation, the Bureau of Indian Affairs, and the tribes just does not exist. So as we talk about management, everyone has to first be at the table in order for that discussion to happen. And just professional courtesy and common courtesy between the parties has to exist. Because again, it's about looking, whose eyes are you in? Whose eyes are you looking from? Because in my opinion, as I've dealt with the state of Wyoming, they're always right. I'm not saying that's what Mr. Tyrrell will say, but that's my opinion of the relationships that we've had with them.
Thank you, Sara. I might refine this question a little bit to also say, are the decrees and the laws governing the various administrators, and I suppose the tribal water code for that matter, are they constraints or are they things to build upon? Is there room for negotiation of sort of things that are like some of the things we heard about in the settlement, so that you can get beyond just, oh, what do the courts say? But in response to Sara, I might see, Lyle, if you want to respond, but I hope you can talk about this overall topic as well.
Okay. What Sara mentioned, she was referencing a project we have that's upcoming with, it's actually Bull Lake Dam. As I mentioned earlier, under one of our authorities and framework that the Reclamation deals with is we inspect our structures and do evaluations to make sure that the integrity of those structures are maintained. Part of Reclamation's dam safety program, under that program there was observed some deficiencies with the original design of the spillway out at Bull Lake. There was some problems with aggregate silica reaction that was causing some deterioration in the concrete. We also had, under that spillway, there was a filter design that was, if water came underneath that spillway and was would be captured and controlled down there without allowing fine sediments or the embankment material to be pulled through, and we found that that filter design was deficient as well. So as part of our dam safety program, we undertook a corrective action study to look at alternatives to address those design deficiencies. And that, I believe, was initiated around the 2007 time frame or earlier. So as Sara mentioned, there was a significant time period before we actually rolled that out even to the public and had communications with the tribes with regard to those corrective actions that we were looking at. So there was some circumstances surrounding that. One, the Reclamation's dam safety program has a limited budget, and there was other priorities at the time that were calling for those monies. So the development of those corrective action alternatives were kind of delayed for a time period. Reclamation, at the point where we had looked at several different alternatives and had one that we looked like was going to address the deficiencies, at that time we rolled that out to the public and to the tribes. Sara mentioned that there needs to be better communication between Reclamation and the tribes. That is the case, and as part of our commitment, one of the commitments we did was that now we meet quarterly with the water board so that we can foster those discussions and communications and let them know it provides a vehicle for reclamation to identify what activities we're taking in the basin, and I believe that is going to be a key to future collaboration and efforts there. With regard to the question with regard to does the current framework or legal framework allow for changes?
Yeah, like your obligations that you mentioned earlier.
I believe that there is opportunities for discussion and opportunities for change. One of the things that an example that I guess I would speak to is on the Shoshone River up at Buffalo Bill. There was a project where we raised the Buffalo Bill Dam, working with the state of Wyoming. As part of that, there was roughly about 290,000 acre-foot of storage space that was provided, that was contracted with the state, and the state essentially paid the cost for that construction. One of the outcomes of that was a winter release, which had a couple of release triggers, which, based on the previous year's inflow, would set that winter release at 100 CFS. And if the past year's inflows exceeded a certain target, we could release 350 CFS for the winter to help keep the river in good shape below the dam. One of the collaborative efforts that came about was Wyoming Water Development Office asked if there was an opportunity to provide incremental releases between the 100 and 350. So there was a period of time where we worked with the Wyoming Water Development Office and looked at if there was a targeting or a mechanism by which, depending on reservoir conditions and inflows conditions on the previous year, we could provide releases of 150, 200 CFS up to that 350. And through that collaborative process, we were able to come up with a revised winter release criteria that provided additional increments of flow depending on the conditions. Between the 100 and 350 would be 150 and 200 CFS. As part of that effort, Reclamation looked at different alternatives. We talked with our existing project beneficiaries, the water users in the basin, made sure that they were okay with the analysis. We entered into an agreement with that was signed by the governor of Wyoming, representatives from the Fish and Wildlife Service.
Thank you, Lyle. I'm worried that we're going to run out of time, but I think you've shown that you guys have made major adjustments.
Okay, but the bottom line is on this: it fit within our existing framework obligation, and we had the buy-in from several interests in the basin, water users, as well as state and federal agencies.
Great, thank you. And I wondered, Pat, you mentioned that example on the Platte, which didn't really involve you guys in the canyon, but excuse me, do you think there are ways to really sort of build on the decree to reach, to still meet whatever constraints affect you and others, but still build on things for change?
I do. I think the decrees on the river, remember what we have here is a litigated result, not a settlement. And so we all kind of have to live with the words of those documents. That being said, and the sideboards on what the general adjudication awards are, whether they're the quantification of the historics or the futures, et cetera, with those as sideboards, I think that there is room underneath the decrees, probably at any time, for a different settlement on how the basin, or especially this part of it, the Wind River side, is administered. But that cannot be a unilateral or a bilateral action. It's got to include, it'll be Reclamation, it'll be other water users, it'll be the city of Riverton, it'll be maybe people below Boysen, because what we can do, if we can move water around to no ill effect on even junior users, then that's something that can succeed. But if we do it unilaterally or bilaterally and just say, I'm going to do it differently, then I don't think you will succeed. Because one of the core tenets of Western water law, of course, is when you do changes, you have to avoid injury. And the only way that I know of to do that is to have everybody at the table when you propose your changes. And if you can get that buy-in, you can develop a settled way of managing the river, then I think you can make changes.
Thank you. I think, can you jump in very fast? Yeah. Okay.
Thanks, Anne. I just wanted to add that it sounds like there is room for flexibility that's coming from both the state and the Bureau of Reclamation. And so one suggestion might be is that, yes, you are somewhat stuck with the, at least, quantification amounts in the decrees, but can you look to other sources of either federal or state law to do things like create a joint coordinating commission or something along those lines, where you can have that kind of coordination and communication happening, but do it and accomplish it through either existing state law or enact a new state law that authorizes that kind of body. And then the other option you might consider is, you know, do you have legal environmental causes of action, some kind of lawsuit that you could bring that would create an impetus to start talking discussions about how you might administer water rights on the Bighorn, and use those vehicles as a way to sort of at least create the will to try to accomplish some of the goals that you seek.
Thank you. I want to move the conversation also to political questions of, is there an incentive, is there somewhere in Fremont County a desire to have a more vibrant economy, and that a way to use water to make that happen? Or do the non-Indians in the county and in the state really not care what's happening in central Wyoming? Is there, what about bargaining power? Is there leverage to pursue both mutual and disparate goals? The paper rights make it seem as if the tribes don't have a lot of bargaining power, but are there some possible bargaining positions, bargaining power to take among the things that Amy mentioned? Also, the question of the vulnerability of the non-Indian users. The Wyoming Water Development Commission has spent millions of dollars on Midvale, for instance, with the federal district, a lot of it for conservation on the Midvale district, so that should the futures water of the tribes be able to be put into use, that Midvale would not be an injured junior user, or not much injury, or could adapt to it. At least that's what it looked like to me when I was on the Water Development Commission. So I'd like to see whether we can have some discussion among the panelists here on those political power issues, and the ability also of the users to get together to try to mobilize themselves to change their relationships. So we'll start with the panelists, and that's when I'm going to start trying to look out there and see who else I can drag into this discussion. Baptiste, we haven't heard from you. Do you want to jump in on that? Or not? It's okay. Sara, you want to be talking again?
Politically, and just in working with the state and the federal government, you know, Wyoming itself as a state is just not very well known to the world in general. And so our issues that arise here, everyone else is not very aware of them. As a tribal member, always having lived my life here, what I have seen as I've become older and as I've worked with the governor's office, with the policy advisors, with the Bureau of Indian Affairs on the water board, is that the tribes kind of stand on their own. In other states, such as in Montana, where you have 7 tribes, in New Mexico and Arizona, where you have larger populations, and other tribes, they carry more of a voice at a state level and at a federal level. And, you know, is at the last state legislative meeting, which was last January, we had to testify to the fact that the boundaries of the reservation did not need to be changed and that state legislators couldn't change them. And that was brought to the floor by a Fremont County legislator. Those are the kind of like daily issues that we're involved in within the tribes, whether it's the water board, whether it's tribal members, whether it's either business council. And so our focus, as many of you may just focus on environment and water, our focus is over many, many things, because it's almost as if every which way we turn, something else is being attacked. Not only in the establishment of our reservation, as it went from 44 million acres in 1863 to 3 million acres in 1868 because of westward expansion. But when South Pass was ceded, it was purchased for $25,000. Even back in the late 1800s, you know, was that reasonable? I mean, no, that's our reality as tribes here who live here, who were born here, and we will die here. And so those are the battles that we have to face, and those are the battles that we do face. And so it comes back to this question of when we're trying to work in collaboration and cooperation, we almost first have to educate. And in doing that, then there's criticism, because I didn't write the history. I just let you know what it is and remind you. And so the distrust, where does that ever end? I mean, we started out with an air quality case that's now about jurisdiction. So who do we trust? Because if we give up just a tiny bit, then you want more. And so that relationship is damaged, and it has to be built again. Because tribal people, as I continue to say now, as we do become more educated, as we do become more knowledgeable, being compliant, being patted on the head and patronized, those days are over. Because we're tired of giving up. And so that is something that has to be overcome. And it has to be overcome with the water, because there are a lot of personal feelings, not just with tribal members, but those that are down the river.
Thank you. I'm going to try to bring in some audience members, and I think I warned you I might call on people. I see Kim Wilbert here, who runs a landscaping and native plant operation in Riverton. And I've always thought that you might have an interesting perspective on what the river could and should be, and also what the politics are. And I need to hand a mic to where'd you go, Jason? Yep.
Actually, I don't have my landscaping business anymore, but I have lived in Riverton all my life and have, you know, watched the river flow by Riverton. I've always thought it was kind of ironic that Riverton is named what it is, and yet the town has so little interaction with the Big Wind River or the rivers period because of various land ownership issues and so forth, and just the fact that I guess the town's use of the river has been industrial over time. And it's also makes me sad on the years when we don't have very good water supply in the basin to see the river flowing through Riverton, the Big Wind River, just at, you know, an almost zero flow. I mean, where you can wade across it without hardly going over your sneakers, and many of the small ditches in the irrigated areas are bigger than the river is left, which means that to me that the biology and the ecology of that stretch of the river is hugely changed and just not even sort of a wild river anymore. And I am interested in this whole water issue just from the point of view of trying to understand how water can be used in the Wind River Basin to everybody's benefit, but allow all the uses, the Native Americans and the irrigators and the folks in town, everybody water to use. I think there's, if we use it correctly and get it spread out maybe differently than we have now, it can be done better.
Do you have any perspective on what the political climate is and if it's changed enough to allow a real discussion and moving on?
I don't really, you know, I don't know how that can happen. I certainly appreciate what Sara says, how to the effect that if I were a tribal member, I think I would feel under assault from almost every direction also. And so, you know, look, as a longtime community member and kind of not understanding, but knowing the big divide that there is between the two communities, the reservation community and the Riverton community, I don't know what the political way forward is. It's a large hurdle.
Thank you. Who else out there might want to comment? Is everybody hoping to sit on their hands and not be called on? Dick.
I'll bring the mic to you. While I'm walking over, the reason I was asleep at the wheel a second ago, many people have requested copies of the final decree. We're going to get a scanned copy posted to the symposium website. It actually consists of 3 orders. Look for that.
Thank you. When all of this started in 1977, we want to remember that it wasn't the tribes that filed suit against the state of Wyoming, it was the other way around. And I'm surprised that there isn't a biologist on that panel. You got state, Yurok, BIA, and as you heard Sara say, I'm glad Sara's on there, up there, and Bat. Because, and in answer to your first question, Anne, emphatically no, the river is not being managed properly. You know, it's easy for Mr. Tyrrell to say, yeah, let's cooperate and get along together. When you But I was in this, right in the beginning of this thing, and because I was a project leader for the U.S. Fish and Wildlife Service and Lander, managing fish and wildlife resources on this reservation, we were the ones that did the studies for in-stream flows. Mr. Tyrrell said, and Jeff Fassett was the state engineer at the time, and I'm trying to be nice. The tribes initiated in-stream flows. Fish and Wildlife Service recommended to the tribes that it be 315 CFS. We decided we'd drop it a little bit because it didn't look like it was going to be a good water year that year, or a really good one. So we dropped it to 252 CFS. Many of you will remember that. 252 CFS. In 2 years, in Fish and Wildlife Service, we were doing population studies and in the river. But within 2 years, with 250 CFS going down the river, fish that were not there or previously there were now starting to come back. I was born and raised in Riverton. We lived about a quarter of a mile from the Wind River. My mom used to take my brother and I and my sisters fishing down there, and we'd use willow poles and a hook and worms and just a short line, and we would fish for lake chub, and they got 7, 8, 9 inches. Those are almost non-existent in the system now. They were coming back. There were a few left, and there still is a few left, not very many. My point is, I'm trying to get to it. We had in-stream flows. Why in the hell didn't everybody get together and support that? The state would have benefited. The Game and Fish was with us. Wyoming Game and Fish was with us, those biologists. BIA is out there. Just think how the Wind River would be now today, after all of those years. As Mr. Wilbrecht said, he sees it. Just think what that fishery would be. Not only the fishery, you could throw the fish and wildlife stuff out. All the other benefits that by having that flow going down the river is what is most important. Whether it's groundwater recharge, whether it's municipal water for Riverton or whomever, whatever. And that's why the water code that the tribes have is so important. Other people don't want to recognize that, of course, particularly the state. But we have 15 or 16 beneficial uses, and not one of them is more important than the other. We have ag people that think that ag is more important, and it is important. I'm not saying fish and wildlife is more important than those. However, most people that are in the outdoors do fish and hunt. So why in the hell didn't we all get together when we designated the in-stream flow and all join? The state would have benefited. Water was still going down to Boyson, just like it is now. Well, it's our future's water. By the way, I wanted to say before I quit, 37 years. 37 years. How much water are the tribes using? Future's water? I don't think I need to say anymore. I mean, this picture is bad, and your name in the red. I'm glad you're here and talking about some of those things, because that's exactly what we need to do. But as long as we have opposition from and federal agencies that are dropping the ball and not living, they talk about trust responsibility. Give me a break. They don't even consult the tribes. Made a major issue on Bull Lake, one of the best fisheries in the state of Wyoming. Could be a lot better if we had cooperation from state, Midvale, and Yurok on how that should be managed and how much water is being diverted. You got to see the waste going down the system. They're filling Boyson because there's so much wastewater coming off of the Midvale and the sediment going down 5 Mile Creek, and the reservoir's not going to last as long as they thought it was. Please give me a break.
Thank you, Dick. I think, excuse me, in blue. Oh, that way, Jason. And then I'm going to get back to the panelists, so be letting me know if you guys want to comment.
So as a continuation, my last little interlude, there are hard copies of the final decree on the registration table if you'd like them.
I want to thank Sara for the good words she said. And my name is Patricia Burgee. I served on the Tribal Council a few years back. And I'm actually running again. But I want to also thank Amy. I think that's just a wonderful words that you said. And I think we need to take advantage of those opportunities like that. And I think need to work together to make all of the water decree work for all of us. So I want to thank everybody up there, Bat and Mr. Baldus.
Thank you. Let me, for a minute, go back to the panelists. Or it looks like maybe you do? Okay. Or John? Or, yeah.
I guess I just wanted to talk about, there's been a few things we've been working with the tribe on. to kind of help the fisheries and stuff, mostly on the Little Wind. And in 2005, 2006, Congress authorized $15 million to go to irrigation projects, and $3.5 million came down here to benefit the irrigation project, and the state of Wyoming matched that. The Wyoming Water Development Commission matched that with another $3.5 million. So we had $7 million to work on rehabilitation of the project. The tribe contracted the work, and they're the ones that worked with the state to get the funds. So that was really good. And then the tribe elected to put fish ladders on our diversions as they were being replaced to help the fisheries. And in doing that, and I guess people that went out to Ray Canal yesterday, you went out to the diversion, you saw the new structure. Basically, the old structure seeped a lot, and the new structure doesn't seep, and now, but with the fish ladder and then the fish return from the fish screens, we're keeping probably the same amount of water in the stream, maybe a little more than in the past. But from that, all our diversions we're putting in are getting fish ladders on to help the fisheries. That was interesting.
Not a tornado.
The Fish and Wildlife Service and I guess they had some private entities helping them, and then the BIA funded the fish screens that went in there. The tribes operating and maintaining those and everything. There was issues for the first 2 years of the operations. We've been working with the tribes and the Fish and Wildlife Service on that diversion especially. And of course this was a wetter year, so things worked better, but we're hoping that things continue to work good in the future, that we're willing to work within our means that we can. Unfortunately, on the irrigation side, we have to deliver the water, but we do want to try to keep as much water in the streams as we can.
Thank you. So the people of the Klamath River have been in your shoes before, and right after the fish kill, things got really bad, and on both sides. For a long time, the slogan of the non-Indians, and this was totally public, was "Save a fish, can an Indian." That just kind of tells you how bad things were. But they also realized that they couldn't continue unhappy. So what they did, even though they were, really, really mad for a long period of time at each other, they got together and they had a big feast. And the tribes brought up salmon, and the irrigators up there, they grow potatoes. And so they brought potatoes, and everybody got together, and it was huge. There were tons of people there, and they shared a meal where they ate their salmon and they ate their potatoes, and they just sat and talked and just shared a meal together. And I know that sounds simple, but it was a turning point in the political relationships between everybody on the river. After they shared that meal together, what they ended up doing was setting up some informal meetings between, some of the key people, and they just started talking. And I think a part of that shift was that in a non-confrontational environment, you can sit down and talk about your kids, for example. You can sit down and talk about what it's like to fish. You can sit down and talk about, being up in the mountains. And at least what happened in the Klamath was that through those discussions, people sort of realized, like, we're all people, and we all want to stay here, and we all want to feed our families and have a future here. And so it became more of an issue about how to live together as opposed to, the Indians and the irrigators. And I know that that getting from one place to the other is challenging, but at least on the Klamath, from that point where we were able to realize we were just people, we could then move forward. And from that, things like the Klamath Restoration Basin, or excuse me, the Klamath Basin Restoration Agreement has come forth, and the Klamath Hydroelectrical Settlement Agreement has come forth. And those agreements contemplate the removal of the dams. They set what they're calling an upside down water right, where the farmers get a certain amount of water for irrigation, but then the rest of the water is left in the river for the fish. There's some habitat restoration. The Klamath tribes are going to get some land back. It does all kinds of great things. Now, those agreements have problems. They haven't been able to be passed by Congress, and so they're not being implemented yet. But the point is that, you know, they took this bad situation, worked together as a community, came up with this historic agreement, and I think the majority of people in the area still believe in those agreements and think that once we get those implemented, things will be better. You know, so that's an example of how you can sort of move forward after, you know, some bad times.
Thanks. Anybody?
I was going to take a little bit of an exception to one of Anne's comments where, and I think I may have heard this a couple other times, that the value of the paper futures, what that may be or not be. I know there's a concern that because they are on paper and have not been built yet, that they have no leverage. I would say that, let me pose a different point of view on that. I do think that there is leverage that is posed by the futures. They are awards just like the historics. They have not been put to use yet, but they, like the historics, they cannot be abandoned. So when you put into context the fact that 209,000 acre-feet of futures in a system right now where the average annual inflow to Boise is a little over 500, between 500,000 and 600,000, so maybe 40% of the April to July inflow to Boise is represented by those futures, I think there is leverage there. The question is going to be, what does the future hold for them? And I think the answer to everything, although there's political work to be done in the meantime, is money. Where will the resources come from to either, and if you lay all the options on the table, either build the futures projects and then do a change? Do you trade the futures for other infrastructure? And I'm not advocating either one of those. I'm just saying that for those to have, that's the value that they represent. Because any water right that you get, whether it's an award or a state-issued right, none of them bring their own water. They have to lay on a system that is a finite water-producing system. They vary from year to year, but the futures didn't bring their own water with them, and when they come to lay on the ground and in the system, that water will come from somewhere. If the system gets built out, we'll absorb them. So that, I think that is the leverage that they represent on into the future. So to the extent that there's any debate about the value of them, I think that there is. It's a question of how to realize that value. Can you build them? Can you use them in other ways? But they alone do not add water to the system. We have a finite resource that either way we're going to have to figure out whether we're managing it today for the best effect of all of us, or whether we can manage differently into the future.
Thank you, Pat. The sorry. Can you let me sort of broach the next thing, because I think what you usually have to say, I mean, I don't mean usually, but the many things you have to say will apply to any question I ask. So I know you're going to get a chance to speak again. I just wanted to say I hope that we could start at this point talking about what steps might be taken toward getting towards this optimal management, towards these changes that people are saying might be possible. And when I've talked to the panelists about this beforehand, and also to others of you, a lot of the discussion has been, you know, there probably have to be some really small steps so that we can get used to working with each other on some of those things and make some progress and not have these huge issues blow up. So I want to ask that question. Pat mentioned an example in the Fremont Canyon, which is not in this basin, but that kind of, are there some concrete kinds of things that might be addressed? And maybe one of them is some of the knowledge-based stuff that we mentioned earlier. Does there need to be a way for people to make sure everybody who cares about this basin has the same knowledge base? This kind of conference hopefully is helpful to that. But, so that's where I'd like to start going. And Dick, whatever you want to say at this point. Nope, okay. Anybody here? Bat, do you have any thoughts on that subject?
I'd just like to add that, you know, there is cooperation between the state and the tribes, other than water rights, but deal with water rights, and mainly those are the current irrigation rehab that's going on now. We've undertaken the task to rehabilitate the major diversions on the reservation. That were left in disrepair. So there is cooperation in that level, and I think it can move on to other areas. I mean, there's a lot of I wouldn't say gray areas, but areas that the state and the tribe can agree on, especially when it comes to the water uses. And I think the biggest thing is our plan of what we'd like to see. And I think it's ironic that when you look back in history, we're new in the game. The decrees and water rights and stuff and prior appropriation and all of that. We're new in this game in this time and age. But if you look back it's always been part of our custom to use the water, traditionally, culturally. If you look at three of the major religions that we do today, the Sundance, the Sweat, and even the Native American Church, those all focus around water. Without water, none of those would exist. And it's just a bridge for us to try to make that connection, you know, in today's date. And there's always a fear that, you know, the tribes are going to take their water and use it for other uses. We have two parts of the award that was awarded to the tribes. One is historic and one is futures. The historic part is all of the historical agricultural uses. And as far as I know, you know, there's no tribal members, or there's nobody in leadership that wants to do anything else with them except leave them as historical agricultural uses. And like Pat said, you know, the futures water, that's something different that we have or hope to have other uses for. When we look at the marketing and transfer of water, the decree just holds the tribes to, that has to happen, the point of sale has to happen on the reservation. And that's something down the road that we could probably work on. I don't know how, I don't have any vision at this point, you know, of how that could be done, but that's something the tribes are interested in, you know, for economic development. And if you talk with a lot of the members of the tribes, you know, they say, well, you know, that's something we should derive revenue from. And it's how you derive revenue and how you, you know, how you come to some agreement or how you work that out. You know, maybe it's possible to go from point of sale from one federal facility like Boyson to Yellowtail Dam, and that would include the Bureau of Reclamation. But then again, you know, those are all things that, you know, that have to be worked on, you know, or discussed on. And I think what I heard from other panelists and stuff was, you know, getting together. You know, everybody has to get down on the same page, and we all have to agree what's best for all of us, or what we'd all like to see. You know, it's a resource we use within the basin. I think it's plenty. We can make it work. Down the road, our goal is to rehabilitate the whole irrigation project. And the way the water was awarded to the tribes, it was awarded based on an inefficient irrigation system, meaning that If this plot of land needed 20 CFS to get to it, then that's why it was awarded. But if you were to go and rehabilitate that piece of conveyance system, then you may only now get it to have 10 CFS to get to that piece of land. That leaves you 10 CFS extra that you can use within the system elsewhere. So there's other things we can do. There's a lot of options, I think, that all parties involved in can agree on.
Thanks. Sara?
I would just say, and just point out that some of the things that we have done, and I'm looking at Mr. Tammany and Mr. Stahl, who's up in the Crowheart area, and that was developing the water user projects. The project that is up in Crowheart was developed and in use, and the irrigators in that area control that irrigation system. And the Bureau of Indian Affairs has taken a step back and outside so that it changed O&M prices that we have to pay. It changed the diversion and where it's diverted and how it's diverted and who is getting what. And that is what the Ray Canal system did. And Mr. Tammany is the president of that system, and he's not a tribal member, but he owns land and has lived within the boundaries up in that Trout Creek area. And over this last 2 years that it has began, I've watched him work 24/7 to make sure that every irrigator on that Ray Canal system gets what they deserve. Because under the Bureau system, which has been operating for years and years and years, they were operating on the CFR. They were operating on everybody gets a fair share. They did not operate the Ray Canal system or the irrigation systems down in our area based on the decree. And they didn't know how to do that. And so the Bureau itself is still trying to educate themselves about what the decree is even about and what PIA is and who gets what water. But when you're a tribal member with allotted lands with 68 rights and you're one of them at the end of the ditch and you paid for 6 months of water and you get 45 days, you're not happy. And so it's just that continual education project. And I think Mr. Tammany should have it, should say what the Ray Canal system has done this year and how it has helped, especially all of the irrigators that are on our system. And I know it's a thankless job.
Do you want to speak to that? Yeah.
I have a microphone for you.
Yeah, first I'd like to thank Sara for her comments. Sometimes when you're working 24/7, you wonder if anybody even notices, but obviously everybody got water, so they're happy. One of the things I've heard here in the last couple of days, and I come away from this symposium thinking that perhaps if we just sit down and talk and come to the table with a good heart and make sure that whatever we decide is beneficial to both parts. When we first started to put this coalition or this irrigation group together, there was suspicion probably on both sides. And through discussion and being open, we had the total support of the Tribal Water Engineers Office, and I don't think that we could have pulled it off without the Tribal Water Engineers Office. And other tribal members who really were very prominent in the formation of this. The conclusion was that it has been beneficial to both. One of the things when we first took over was kind of contentious were the fish screens. We managed to work around that. Hasn't been a problem that we couldn't solve. Here again, I just think that if two sides sit down, talk, and make sure that the benefits are for both sides, and somebody walks away from the table thinking that they won a little bit, maybe they gave a little bit. After all, I mean, life is just give and take, so I think it is possible. We can probably come up with a lot more beneficial uses. We have plans to manage the water better through gauging stations and better control the water and tailwater. And I think that you know, during tough times, we should be able to do a lot better than we have been in the past. One of the things that Tribal Water Engineers Office is doing right now is planning a drought scenario. And this is the time to be doing it. We've had a really good year here, and this is the time to be thinking about bad years in the future. You don't want to think about what you're going to do in a drought situation when you're already in a drought situation. So planning, I think, is the key to success here. But it has been a pleasure working with the Tribal Water Engineers Office. I hope they feel the same way about us, and I hope that relationship continues. Thank you.
Thank you. Gary?
Thank you, Anne. I would be remiss if I didn't say a few remarks at this historic event. But as a former tribal chairman, former tribal water engineer, and a tribal member, and knowing very much about all of this discussion, it is apparent that communication is important. And as a tribal liaison for the Arapaho tribe, working with Sara when she was the liaison with the Shoshones, we were constantly educating the legislative process in Cheyenne. That's the part that changes to some degree. The continuity is people like Patrick Tyrrell, who's in the engineer's office, Nancy McKinnon, and others who've been there for some time and understand a lot about what we do. The communication part should be the strongest between the tribes and the BIA, and that's not always the case. I will say when we did the Safety of Dams project, John Anevski was very instrumental in getting those done because of high priority safety. We secured Washakie Dam for usage for here on out within the irrigation system, but overlapping that is our tribal water code, which allows for other 15 or 16 different usages. The money that was received from the Congress through Senator Enzi's office and matched by the Wyoming Water Development Commission was initiated in the Tribal Water Engineers Office with the Water Board. We secured those funds. We've expended those funds, of which you saw some of yesterday, where we were at the Ray Canal diversion. Had not the tribe stepped up and secured those, we would not have a system today because there would be no way to divert the water. I have great friends within the BIA, including John and others, but the system that they have here is so constrained that none of the projects that the BIA has with irrigation have ever been completed. This one being a significant one, we're looking at maybe $100 million to rehabilitate this system. So the communication part's there. We're trying to make things better, and then we get crosswise with the tribes that states with air quality. Who doesn't want clean air? You know, the acronym is SAFE. Safe air for everybody. But we've got this significant pushback with the tribes wanting to do something for their people and the region, and I think the tribal leadership can't quite understand that, not because of ignorance, but because why can't someone recognize safe air for everybody? And if that comes from oil and gas operations, then we need to adjust how those are operated, because we have oil and gas on a reservation too. So we're looking in the mirror as well when we talk about clean and safe air. So my role in the last several years, personally and professionally, is to coordinate more activity to develop the resource managers for the reservation. I work with Indy Burke here with the Ruckus House Institute and the Haub School, currently mentioning Mr. Fred Tamanay. We are putting together a drought mitigation plan with 4 universities and several federal agencies. And we are looking at including our youth in part of that program to develop that capacity so these kinds of discussions are fruitful and that we can move forward. The Yurok situation with the Klamath River, I've been there. I understand clearly what Amy's talking about, but those of you who haven't been there, the impact's not quite in front of you because you haven't seen that devastation. So the communication is still an ongoing issue. We need to make that happen in every avenue that we can. And the continuity in the water arena from the tribes is the water board. They meet twice a month. They've been doing it for 15 years plus. And so we are here today because of the culmination of the water rights case, but I think it's a beginning of what we need to move forward to how to make this work. And as Mr. Baldus mentioned, we have 30 CFS going down the Big Wind River here at Riverton, and then the return flow off the Midvale Irrigation District gets to be as high as 500. There's somewhere we could make that in-stream flow and that return flow balanced, and that's from communication. You know, the Pilot Butte issue is a good example. The tribes need to be notified how they can participate in that, because it seems as though our federal agencies need to have tribal liaisons. Not me particularly, but you know, the trust responsibility and the government-government relationship is nothing brand new. It's been there forever. It's just not always recognized. So, just a closing comment. I'm appreciative of everything going on here. Jason and all the staff that put it together, and particularly all the panelists and those who've come from afar. What a historic moment. And it doesn't mean this is the only one. I think we should do something again in 5 years to see where we are. I'm sure we'll still be in business here, but it's a great venue to have opportunities like this. But we really need to be more cognizant of what's going on the ground. And the future water issue that the tribes have ties in with the future of the tribe, both tribes. And so, you know, the story goes on. But the validity of what we're talking about here of water in the West is very paramount for all of us. Thank you.
Thank you, Gary. I'd like to turn back to the panelists for a minute. Also, some of the, whether there might be specific examples, even though they might not really work, but they might spark ideas. I've heard people talking about, gee, is there a way we could do major irrigation down here in Riverton that would pull water through on the Big Wind and therefore get water there? Now, I've wondered, major landscaping around that casino benefits the casino. Yeah, let's go for it. That's just my little ideas. Or parks along the Big Wind. Anyway, I wanted to ask, Pat, whether you have, because you mentioned earlier small steps, things people could work on. Is there any example? You mentioned a few already, so you may not have anything you want to add.
Well, I would. There is one other example that is actually in process right now, and that is in our own Laramie County. We have a groundwater control area, and 2.5 years ago, because of declining groundwater levels, we issued an order that essentially does not allow the permitting of any high-capacity wells out of the Ogallala until we figure out going forward how to manage that resource sustainably. Now, under statute as well, for groundwater control areas, the appropriators can submit a plan to the state engineer for approval, where they say, here's how we think we can manage going forward. And down there, the tough nut to be cracked is The only way to recover groundwater and to make that aquifer sustainable is to actually pull some uses out of it. We're going to have to buy and dry. We are pumping in parts of that county more water than can recover the aquifer, and people end up pumping air midsummer just about every summer. So part of the goal going forward, certainly in the appropriators' minds, is we got to get some of these marginal lands and wells removed. But how do we do that? The statute is very clear in that it says that the appropriators can bring their plan to the state engineer, and as long as, number one, it's not adverse to the public interest, or number two, that on review I can see, or our staff review, that it doesn't injure anybody who's not a party to it, then we can approve that document, and those irrigators or the people that have brought that forward have at that point taken control of their own destiny and what the management of the Ogallala looks like going forward. The problem there is a similar one to what's faced here, and that is it can't just be the irrigators bringing the proposal forward. They've got to engage the county. They would be wise to engage the city of Cheyenne as a nearby groundwater user who just happens to be outside the control area, but they are a political force in that county. They've got to talk to the county planner, the county commissioners, the municipalities of Pine Bluffs and Carpenter and Burns, and make it a holistic, broad-based net that is cast in creating that management scheme. If that can be done, and we can figure out a way to handle fiscally or financially a way to either partner with NRCS or the state or some other way to gather funds to begin to pull some of those demands out of the aquifer, then it will succeed. So this type of coordination and collaboration is actively going on in other parts of the state. The problem is a little different, but the hard work that is needed and the perseverance that is needed is going to be pretty darn similar.
Thank you. Over there.
Zambechu. My name is Darwin St. Clair Jr. I'm the chairman of the Eastern Shoshone Tribe. First, I'd like to welcome everyone. Thank you all for attending. A historic event. However, I hope that this is not the end, that this is only the beginning. And as we talk about communications, there's not only communications that the tribes need to have with the state and the state water engineer and those people, but also with the federal government. And currently right now, as you all know, that we have 3 storage sites that reside within the Wind River Reservation boundaries. Bull Lake, Pilot Butte, Boysen. And what we really need to look at as part of this moving forward and part of this communication is that how do the tribes, and for some odd reason, the tribes are not able to store their water. However, we have 3 sites that water is stored. So we've got to have some communications and dialogue and some resolution to getting some of this done. Because perhaps it might save everybody a little bit of money in developing more storage sites. And so we need to look at those things as far as future water, as far as storing water, as far as where are we going. And then I would suggest that the Bureau of Indian Affairs and the United States government has a trust responsibility to the Eastern Shoshone Tribe and to the Northern Arapaho Tribe to store a little bit of our water in those facilities. That might be economically possible and should probably be something that's happening. The other part of it is as we have heard, is that there is more efficient ways of delivering water. And as we get more efficient, doesn't that mean there's more water left over? And that how can we use that water that's left over? The other part of it, as I see in the future, is capacity building. How do we build our capacity? How do we get tribal members to become tribal water engineers, hydrologists, engineers, agricultural people? we have all those needs. And probably all Indian nations have those needs. So part of this is, I hope, is only the starting point of more communication. And being a historical event, as someone had said, maybe we should come back in 5 years. Well, hopefully, in another 37 years, we're far beyond where we are now. And I really hope that this is not only about who gets what and where it goes, and I know as the tribe, the Eastern Shoshone tribe, we have historical ties here since time immemorial. We have been here forever. We know what we have. We know that we have over 200 mountain lakes. We know that we have water that runs down our rivers every year and goes someplace else. But yet, our system is still depleted, inefficient. And so I hope that this will spurn the opportunities for everyone to dialogue and to communicate and to move forward and hopefully be further along than where we are now. And I really think that we do need to look at those discussions with the federal government. And we do have some of the best fishing probably in the whole United States, right here. There's a reason why the Shoshone are here. There's a reason we picked this place out of losing 44 million acres. There's a reason we're here. And historically, we have been here forever. And so as a Shoshone tribe, we have to defend this. We have to make sure that things are appropriate. And we have to make sure that we are getting assistance in building our capacity so that everybody wins, so that everybody gets something. And I think that's really vital, and I think that was one of the things I learned when I went up to Worland recently. And many times when you're in negotiations, and many times when everybody has a need, not everybody's happy. But as I understand, when everybody's not happy and we all had to give something up just a little bit, then it benefits everyone. And I think here today, that's what we're doing. And my hope is that we continue to move forward, that we continue to build capacity, that we continue to progress with the technology that is out there, and that we get assistance from our federal partners, from the state, and from other Indian nations to continue to proceed. So I'd like to thank you all. Hui-hoo.
Thank you.
I want to thank the chairman for his remarks, and secondly, I want to challenge him to a fishing competition. We always say that we have the best fishing, but maybe you do. Maybe you have the best. Well, I wanted to take this time to make a recommendation or a suggestion about how you may move forward. So one thing you could consider is either through federal or state law, and I sort of mentioned this before, is creating a joint coordination commission, you know, something that would look at these issues and try to come up with solutions that meet everybody's needs. And I think a key to that would be making sure that you have representatives of the federal government, the state, and the tribe, and that in that whatever sort of law or articles of incorporation, whatever it is that creates the commission, it says that you are working together on a government-to-government relationship in a way that honors that trust responsibility that the federal government has to the tribes. But then in addition, one other thing we've been seeing, I've had the pleasure of working with different communities throughout the country on these kinds of issues, and sometimes you'll even see the state being willing to adopt sort of a trust responsibility towards the tribes, and recognizing and acknowledging that government-to-government relationship. So, you may consider creating something along those lines, some sort of organization that works together on a government-to-government basis, and specifically some of the things that I heard yesterday about joint projects could be, joint inspections of the Walton projects. Maybe looking at how you could help the BIA manage the Ray Canal. And of course, the transfers is going to be another big issue as you move forward. And then again, new storage. How do you increase the capacity of the system? And potentially, new storage could sort of alleviate some of these concerns. And the other thing I thought too, and I hope I don't get in trouble for saying this, but I'm just going to say it, is, it seems like the tribes are really interested in the in-stream flows, but are there ways under state law that you could have in-stream flows in the river? Is there state law that would allow that kind of thing? So if it doesn't come from the tribes, what other avenues do you have to create those in-stream flows?
Thank you. Dick, you're so knowledgeable. I wondered if you'd talk a little now at the end, and whatever you might think is appropriate as we come to the end of this discussion.
Called on in class. Yeah. We need to move forward. 37 years and not being able to use, the tribes not being able to use futures water, ridiculous. And as I said before, the tribes had in-stream flows, and if we had cooperated, I remember that it was said that, well, if the tribes put the in-stream flow, the 252 CFS down the river, that the farmers, Midvale, LeClaire, and irrigation districts wouldn't have enough water for irrigating. Well, guess what? That wasn't a high water year, the second year. It was a medium year. Well, guess what? They all said in their own media releases, Midvale, LeClaire, and Riverton Valley, they all had bumper crops. Well, come on. And, I agree with everybody that we need to cooperate, we need to get together, and that's true. And I'm a tribal member and on the water board, been there for a while, working with Sara and Bat and many other people that are in this room, and we're doing some good things, and we are working with the state, and Wyoming Water Development Commission has been very helpful. Without them, some of the irrigation stuff and some of the other things that are being done wouldn't have occurred. So I like this symposium. I don't know whether we ought to wait 5 years, Gary. I think maybe we ought to, we need to move. It's like Mitch Cottoneer, our tribal water engineer, he said, we're looking at storage. Well, we don't need storage, and we've been talking about this for, I don't know, 20 or 30 years, and nothing's happened. However, if the irrigation system that BIA started over 100 years ago had been completed, we probably wouldn't need much storage. We do need a little bit, no question. But, and then the other thing that goes along with that is efficient use of water. Western water law has outlived its usefulness. That gives the state of Wyoming and other states, not just Wyoming, everybody a legal right through the state engineer's office to use water any way they want. Waste it. And it's being done every day, now whether it's on a reservation or wherever it is. We need to change that. And then we have more efficient uses of water. And like the chairman said here, Darwin, we've had some major changes in how people irrigate, gated pipe, sprinkler systems, whatever. Where'd the water go? Where's that excess water? So these kinds of things are great. We have a lot of good people here, and I think that the other thing that it does is it brings everybody kind of up to snuff on where everybody is, and what some of the problems are. And okay, those problems are there. How do you solve them? And they can be solved. It's just people have to think about it.
Thank you. I think that we should shut down. You guys have been sitting here for 2 hours. I want you to thank our panelists who put a lot of time in advance into thinking about these questions and figuring out how to speak to you about them. If you could thank the panelists. And I think Jason is about to give us more instructions.
After that intensive lecture, you get a 15-minute break to kind of process everything. We'll reconvene at 10:15.
I was wondering about that. Amy, pleased to meet you.
mix it up. You want to look like we're in battles.
So as far as the format, I've drawn info from your bios and supplemented it with stuff that I know or have kind of gleaned. I'll be pretty quick. I think we allotted 5 minutes in total. And then I'll turn it over. I will, in the intro, mention the 3 questions that we agreed on to structure the panel as a whole. So I'll lay out those 3 questions initially, I'll lay out your bios initially, and then I'm going to step back and let you offer your remarks. I'll keep time. I don't know if, actually I should ask, do you want me to keep time? I feel like I should in case you go over your 15 minutes.
Yeah, I'd like you to.
Okay. Can I ask one favor? I should have mentioned this earlier. I'd like to sit here because I want to slide you these if I need to. 1 minute, 2 minutes, 5 minutes. Is that okay? Could you folks just sit down one seat? Thank you. So I'll keep time. I have the... Yes. No, I'm going to... I'm going to say this about scholar. You know, how to be interested in Wyoming before, right? Yeah. So I'll just... So the overall time structure, again, the audience, this is where I was leading. So 5-minute introductions, 70 minutes is the way that I just described. 15, 30, 15, with 10 built in for response time. And then at the very end, I've set aside 15 minutes for calls. But into that, we just have room for 2 minutes. I'd probably be multi-controlling as a junior scholar, but I'm so, this is all right. Good deal, thanks. All right, ladies and gentlemen, could you please make your way back to your seats as soon as possible? We have one more panel. Consists of a proverbial brain trust. You don't want to miss this one. There might be pyrotechnics afterwards. We might have to call a fire marshal. Please go back to your seats. Ladies and gentlemen at the back of the house, please find your way to your happy places. Metaphorically and geographically, please find your way back to your seats. May I ask folks in the back to shut the casino doors? All right. That last panel is a challenging one to follow on the heels of. What an amazing discussion, useful discussion, and as was mentioned by several people, hopefully a precedent for what comes forward. We do have one more panel, though, left. This panel will span until about 11:45, and we'll then go to lunch. I will moderate it. You're not allowed to throw things at me if you're sick of me, but you can say things under your breath, and internal dialogue is totally fair game. So this panel is an intrastate regional panel. The general focus of this panel is on the role played or role to be played by general stream adjudications like Bighorn in Western water management from a regional perspective. We've had the good fortune of getting agreement by 4 accomplished water law scholars and practitioners who've done work in this area and who've written scholarship in this area. I'm going to introduce them, and at that point I will turn the panel over for a series of presentations as well as some Q&A with the audience toward the tail end of the panel. So just to clarify the format, I'm going to introduce the speakers initially. They'll deliver presentations. If you have questions stemming from their presentations, please jot them down, because I have built in a little bit of time at the end of the panel for open audience Q&A, and my colleague Deb Donahue has a microphone to facilitate that. All right, I'm going to introduce the panelists in alphabetical order. The first panelist is my colleague Michelle Bryan. Michelle teaches at the University of Montana Law School in the Natural Resources and Environment program. She's also the co-director of the Land Use and Natural Resources Clinic. She was born and raised in the West in farming and ranching communities. Prior to entering academia, she worked in private practice representing a variety of clients on various natural resource matters. Her talk will be focused on a recent bit of scholarship that she and students affiliated with the UNM Clinic have produced on water rights, a study specifically that examines how each of the Western states integrates adjudication with other water rights proceedings. That's Michelle Bryan. Next on the panel, at least in alphabetical order, is a real force of nature that goes by the name of Burke Griggs. Mr. Griggs has joint appointments here in the U.S. Academy, an appointment with KU Law School on one hand, and an appointment with Stanford University, specifically the Bill Lane Center for the American West at Stanford University. Mr. Griggs' background is very interesting. He holds a PhD in history from Yale University. He taught as a professional historian for roughly a decade back at Boston College before transitioning to law as a discipline. Since focusing on law, not only has he done academic work, but he also represents the state of Kansas in federal and interstate water matters, including litigation before the U.S. Supreme Court, arbitration based on court decrees to which Kansas is a party, and Interstate Compact Commission, Interstate Compact Administration work. He's an advisor to governmental entities on a number of natural resource matters, including water rights matters. Next in line is my colleague, my predecessor at the University of Wyoming College of Law, Dr. Larry McDonald. Many of you know Larry. We have the good fortune of encouraging him to drive up from Boulder to be part of this conference. Larry's been a member of the steering committee that put together this program and helped with this panel as well, an invaluable asset in terms of contributing to what all of this should look like. Larry's career, very nuanced, very accomplished individual. In addition to his University of Wyoming stint as a law professor, he was the first director of the Natural Resource Law Center at CU Law School, and he also served as an attorney and consultant in Boulder, Colorado, in both capacities for over a decade. Currently, Larry teaches on the adjunct faculty, including water law courses at CU Law School. He works on a number of different scholarly projects. I envy the time he has for all of those. One of those projects is a recently published treatise on Wyoming water law. I believe it's the only exhaustive source on that subject that currently exists. Rocky Mountain Mineral Law Foundation published it earlier this year. There are copies on the registration table for anyone who's interested in learning about the nuances of Wyoming water law. It's a very useful source. So thank you, Larry, for being here. Last introduction, a colleague from University of Idaho. I think I went in the wrong order. I promise I do know my alphabet. We have a colleague who's come over from Moscow, from University of Idaho College of Law, Barb Cosens. Barb's extremely accomplished in this area, again, both in an academic and a practical sense. She's a professor at University of Idaho College of Law, as well as with their Waters of the West graduate program. Her kind of focus at U of I is on water law, water policy, law science, and the environment. She also teaches an interdisciplinary graduate course on methods in water resources. incredibly accomplished scholar, research interests over the years, and currently have encompassed subjects such as water governance, dispute resolution, adaptive water governance, and the recognition and settlement of Native American water rights. So individuals from our sister states and then some, please join me with a round of applause in welcoming them. The questions around which this panel is framed are threefold. We agreed on these ahead of time. I'm going to note the questions initially now. Perhaps the panelists, when they come back up, can reiterate them. But there are three things that this panel is going to address. An initial question, which will be addressed by Larry. To what extent have general stream adjudications succeeded or failed in accomplishing the goals they have been implemented to achieve? Question 2 will be tackled by Barb and Burke in a joint presentation. What advice would you give Western states regarding how to successfully implement general stream adjudications? What alternatives to adjudications should be considered by Western states? And question 3, which will be addressed by Michelle, are general stream adjudications relevant to Western water management in the future? Exactly what role will they play? We've allotted about 70 minutes for these presentations. As I mentioned a moment ago, when the presentations are completed, I'll open it up for some audience Q&A, maybe 10 or 15 minutes of that. Without further ado, though, I'll turn the podium over to Larry McDonald.
It's really wonderful to be back in Wyoming. I had the pleasure of teaching at the law school in Laramie for 4.5 years, and it's been really fun to come back and see many of the friends that I made and people that I got to know a little bit and meet some new people as well. It's a pretty exciting event, and I think I feel very fortunate to be a part of it. We're going to take a little bit more of a look at the broader world in which this whole process unfolded and see if we can sort of offer some perspective on that. So let me see if I can make this work. Oh, right there. Okay, great. So Jason has already said the part of the assignment that I took on was the first question. To what extent have general stream adjudications succeeded or failed in accomplishing the goals that they have been set out to achieve? And so I thought I would just look and first find what the stated purposes were of the Bighorn and sort of start with that question. So what the law and what the process set out for us here in the state was to first confirm existing decreed or adjudicated rights. The state of Wyoming, as you know, has its own adjudication process. So confirm the existence of those adjudicated rights. Secondly, look at the status of uncanceled permits. The state of Wyoming has a large number of permitted rights that have never been adjudicated or certificated. So, what's the current status of those rights? And then finally, determine the extent and priority date of any other right. That, of course, were the tribal and federal reserved water rights. So those were the stated purposes of the Bighorn adjudication. And if you take a look at the outcomes, first, all of the certificated or decreed water rights were confirmed in the final decree that was just signed last Friday. And so the fact that that had happened within the Wyoming administrative process enabled the parties to agree there was no need to go back and re-examine those rights. I think that is illustrative of the really excellent job the state does in its adjudication of new water rights. And Pat Tyrrell has already given you some of these numbers at the very beginning of this conference, but about 30% of the outstanding surface water permits were adjudicated, meaning that when the state examined whether there was in fact beneficial use occurring under those permits, about 30% of them turned out to actually be in actual use, and that meant that they were able then to get a certificate that said, yes, you have put your water to beneficial use, therefore you have perfected your water right. There were a much larger number of wells. Most of them, though, were the small domestic stock or domestic wells. What the state did with that was really just kind of pull them into the process. So we had only about 500 or so groundwater wells that involved large-scale beneficial use that were in need of adjudication. That was completed. And then, of course, the part that we've been talking the most about over the last day and a half here is The outcomes respecting the tribal rights that we've already mentioned, and in addition, I think you heard the federal government settled with the state the claims that they had for the lands, the federal reserved lands in the state that were non-tribal, and those were all included in the decree. And so a lot of things were finished and accomplished in the process of this adjudication. You know, just to offer my perspectives on how well we did, I think from the state perspective, and again, I'm not the state, but let me just say, I think that the state would say, yes, this was a successful proceeding. It was, we recognize, timely. It took a lot of time, 37 years. It cost a lot of money, but we accomplished the objectives that we set out to accomplish. If I were a state water right-based user, I would have a probably somewhat more mixed perspective on this. Yes, it's nice to know what the extent and nature are of those federal claims that were out there undefined. But other than that, I might not view that there was a whole lot of improvement in my circumstances. Things were pretty much the same before and after the adjudication. Federal lands, as I mentioned, that did resolve itself through settlement, so my assumption is that the U.S. was content, since it agreed through settlement to the outcomes. But as we've heard, the tribes, I think, were not, and they're, as you are learning, if you haven't been in this process long before, still wondering, you know, what it is that they really did gain through the proceeding, and hoping, thinking that there may be something more out there. All right, so, you know, thinking then more broadly about the concept of general stream adjudications, what, you know, in kind of standing back and thinking about that, and this is really informed by my years here in Wyoming, where I became much more familiar with this state's approach, beginning with Elwood Mead back in 1890, where the state adopted a somewhat different approach. Colorado had led the way in the world in which there was no state administrative proceedings to resolve issues of who has the right to use water. So under the pre-existing approaches, it was kind of a free-for-all. People went out, kind of staked their claim to water, used it, maybe recorded that they had a claim in a state county clerk's office, but there were really no clear records. And so the response to that initially was, well, what do we have to resolve, you know, who really has these claims and what are those priority dates and what's the extent and nature of the right? In the 19th century, we turned to courts because that was a mechanism that was available to us. But, you know, what Elwood Mead found was that there might be better ways to do that. And he brought that learning here to Wyoming. We created a state board of control. We empowered that administrative body with the authority to adjudicate unadjudicated water rights, and then as new claims went forward, to certificate and or adjudicate those rights as well. So that process in this state has worked extremely well over the years, and I think when one thinks about, is it necessary to go through this kind of very prolonged, expensive, and of course legalistic approach, is that a necessity to resolve the question of title to water? I would say the answer is no. There are alternative options that, you know, the state of Wyoming, I think, leads the way in. There are issues respecting the uses of water that do remain, and we need clarity in those, so you know, that has to be done. But certainly if one were to simply say, you know, what we're really concerned about is, gee, a lot of people haven't come to the state and gotten clarity on what the priority date is or nature and extent of the right, then, you know, we can do that through existing law, and all we need to do as a legal obligation or as a legal matter is to say to people, you know, in order to have a protected, vested water right, you're going to have to come forward on your own initiative and get that certificated with the appropriate state authority, whichever that is. That's very clear here in this state. And I think one of the important messages that would motivate people in going forward and doing that is that they need to understand that unless and until they have gone through that state process, they don't have a perfected water right. They have a permit perhaps, or they have their claim, but unless and until the state has acknowledged that in fact is a completed water right, that water has been put to beneficial use and all of the prerequisites of the law are met, then all you have is a piece of paper or a putative right to the use of water. So, these are things that I think really can and could better be done in alternative mechanisms. The big driver, as I think you all are aware, to the use of general stream adjudications in many states has been the ability through the McKinnon Amendment to require the U.S. to come into the state adjudicated procedure in order to get determination of federal and Indian reserved water rights. And that came out of an interpretation by the United States Supreme Court in two cases that decided that yes, in fact, even though the McKinnon Amendment really made no reference to the requirement for federal water claims that included reserved water rights, the court decided that yes, determination of those reserved water rights also could and should occur through an appropriately established state adjudication proceeding. And the theory, the basis that Justice Brennan articulated as to why that was appropriate was this statement: avoid duplicative litigation, tension and controversy between the federal and state forums, hurried and pressured decisions, and confusion over the disposition of property rights. So that was, the articulated basis on which the United States Supreme Court said, yes, so we think it's better for the states to resolve these issues. But there were contrary views, there were dissents in these cases, and I just want to give you a flavor of what the concerns were. Justice Stewart in the Colorado River District case pointed to the fact that the federal reserved water rights, including tribal reserved water rights, are federal law. And that, in his view, it would be preferable that those determinations be made in federal courts, given the fact that this is federal law. And so you can see the kind of language that he used there. He also specifically referenced the criticality of these reserved water rights decisions for tribes, and the need to ensure that the tribes would have the appropriate forum for resolution of those issues. Justice Stevens pointed out another issue, and this has to do with the question of if we're going to resolve these issues in state courts, then we're going to have different outcomes in different state courts. I want to talk a little bit about that. What I did was to focus on state Supreme Court decisions made respecting federal and Indian reserved water rights over the last 30 years. And I think it's interesting to kind of see what the different state Supreme Courts have decided. We have consistency of view on the fact that multiple sustained use is not a federal law that is the basis of a reserved right in two states, but of course, other states might come down differently on that. For public water reserves, we have a difference between Colorado and Idaho as to what the extent and nature of the use of water is for public water reserves. For wilderness areas, the state of Idaho, initially the Supreme Court decided, yes, there are reserved water rights for wilderness areas, and then, you may be familiar, there was a political backlash against that, and the court reversed itself. Then, in the national recreation areas and national wildlife areas, the Idaho Supreme Court went behind the stated language of the purpose of these reserves and found other ways of defining what the purposes were, and on the basis of that decided that no water was necessary, and therefore decided there were no reserved water rights associated with that. We have conflicting views on whether precedent from these federal reserved water right cases should extend to and apply to tribal reserved water rights. So here in Wyoming, the Wyoming Supreme Court said, well, no, they're not, it's not a required precedent, but it does serve as guidance. If you read Bighorn 1, I think you see in there that they really use this primary-secondary distinction that has been developed in the context of federal reserved water rights. The extending to groundwater issue here in Wyoming, we decided no. In Arizona, they decided yes. In the Bighorn adjudication, we decided agriculture only. Montana said Indian self-sufficiency, and down in Arizona, they too have followed a kind of a development of that concept. In keep this going. Your dispute management issues, we've heard here in Wyoming, we agreed that the state engineer could administer issues on the reservation. Washington said no, only courts can do it. And then the question of can new water rights be issued on reservation to non-Indians while an adjudication is pending. Montana initially decided no, they couldn't because we didn't know the extent and nature of the tribal rights. Then again, politically things changed up there and they changed their mind. So we see a significant difference, I think, in what has come down in different state court interpretations of federal law. And I think it kind of highlights Justice Stevens' concern. Is it appropriate for federal law decisions to be made in state courts, given, again, how important they are, and of course the perspectives. I think Sara Robinson's, what eyes do you see this through is particularly relevant. My views have come to the point where I'm thinking that there are alternative mechanisms that would be much more efficient and effective for accomplishing the objectives we're talking about, and we may have an opportunity to talk more about those in the next segment. Thank you.
Thank you very much to Professor McDonnell. I'm going to check the other mic here. All right, we have time for one, maybe two responses from panelists. As I mentioned at the outset, there'll be open Q&A with the audience at the end of the panel, but up here on the stage, would one or more of you like to offer thoughts on what Larry has shared? Do I need to use the Socratic method? Thanks, Barb.
I'll bite on that. God forbid the Socratic method. I agree with what Larry said about what we've seen real differences among states with respect to federal and Native American water rights, and that's disturbing, and it does raise the issues that Stevens raised in the San Carlos case. One thing that Wyoming did not use, but that other states have used that has mitigated that somewhat, is the federal process under the criteria and procedures for settlement does take sort of a uniform approach to how the federal government will represent and work with tribes in settlement discussions, and how they will go about considering what funding would be available. And I think if you look at the settlements, they're all tailored to the specific Indian reservation because the people actually came together, both Indian and non-Indian interests, and designed their own settlements. But overarching parameters in terms of what's accomplished, how they're funded, there's a great deal of common ground. So the settlement process has actually mitigated some of those differences that we see between states when these issues are litigated.
Thank you very much for that input. At this point, I'm going to ask Barb, Professor Cosens, to come up to the stage. As I mentioned at the beginning, she and Professor Griggs will be delivering kind of a joint presentation, and Professor Cosens will speak first.
Okay, thank you. Well, as Jason said, well, first of all, I'd like to thank the tribes for hosting us here. This has been a fabulous venue and a fabulous gathering, and also the University of Wyoming and Jason's heavy lifting in herding cats the entire time through this has been really wonderful. So as he said, Burke and I are going to join together on this talk. What we wanted to talk about are some of the lessons that have come out of Western water adjudications, and then we're going to take kind of a different context in order to really highlight the questions of when might those lessons apply and when might they not, and Burke is going to introduce that context, which will be the Ogallala Aquifer, which is a multi-state groundwater. Do I just do the arrows? Okay. So this is kind of the organization of our talk. You may not be able to see it, but I'll read it. And basically, the lessons that I'm going to go through, we've learned a lot about managing complex litigation, and that can apply to other adjudications and other aspects, complex litigation that courts deal with. We've learned a lot about tailoring evidentiary standards to the type of issues that come up in water cases. The development of technology was already talked about a lot yesterday. I'm just going to illustrate some of it for you so you can really get a feel for what's been developed that's going to help going forward with water management. The importance of dialogue. You keep hearing that over and over and over again, and I'm going to try and put it in a broader context for you today. And then finally, the caution about cost and finality. High cost, and this is not final. And then when we go to the application, we're really going to look at what's a threshold question, and that is, given the problem, is adjudication the answer? Because it's not the answer to every water problem, and because of the cost, you want to tread very carefully and be ready to go forward with funding it. So first of all, managing complex litigation, I just have maps up here that show two of the adjudications in the West, the two that I've been most involved with, and that's Montana and Idaho's. And a number of things that the courts have come up with in order to handle the sheer volume of claims and people involved in these adjudications. And what you see on the map is one of those organizing principles they've used is to divide the basin up into sub-basins. And so you take smaller watersheds and do them piecemeal, issue preliminary degrees, and at the end of the day bring them all together. Well, that's a nice way to bite off chunks geographically, but the problem is that there are certain issues that are going to be cross-cutting, and they're going to come up over and over again in every basin, and if you deal with them piecemeal, as judges change, as new attorneys come in and brief these issues differently, all of a sudden you're going to come up with different answers, and you'll be treating people in one part of the adjudication differently than in another part on similar issues. And so a good example comes from Idaho of how they handled it. Basically, anyone within the adjudication could petition to have a particular issue designated as an issue of basin-wide concern. Federal reserved and Native American water rights are issues that were designated of basin-wide concern, but many other issues that had to do with the procedures in the case, how water rights were going to be defined, all of those were issues of basin-wide concern. They could be immediately litigated, and anyone within the adjudication could file a brief on that, and then they could be immediately go up on interlocutory appeal to the state Supreme Court. So you could have an answer then that could be applied in every single basin. And so I think the courts have become more and more sophisticated in how to handle this. Evidentiary standards. If you're talking about recent uses, like a lot of our major groundwater uses, this might not apply. The people who were around when big wells were drilled are still alive and can still submit affidavits. But when you're talking about surface water, and we heard yesterday in New Mexico, some of the water uses for Spanish land grants were developed as long ago as the 1500s. You don't have anybody around that can testify as to when it was developed, so the priority date, and how much was used. And so a lot of it is going to be oral history, and we've learned a lot in courts in litigation over tribal issues that oral history is valid and it can be validated. Well, water courts have learned this in general, and that you can take evidence that in another court might be considered hearsay. Well, great-grandfather always said that they finished the canal a week before he and great-grandmother got married, and here's the date in the Bible of when they got married, and that's the evidence they have. Well, is that hearsay? We allow that type of information to come into court and look for independent evidence to handle it. One of the big messages to come out of adjudications is the development of technology, and when most of these adjudications that we've talked about here started, we didn't have GIS available, and we didn't have the ability to put all of the documents on a website. But today we do, and for any other state or group looking at adjudication in the future, they can learn from what we've developed on those and then continue to advance the technology. And I just want to show you how important this is. Judge Guthrie and I had a conversation the other day about the legacy of these adjudications, and their legacy is only as good as the tools you make available for the next generation to manage these water rights and continue to resolve and improve their resolution of disputes concerning them. And technology can help you with that. So at the start of these adjudications, this is what you had for a water right. This is the legal land description of where this water is going to be used, and you would have reams and reams of lists of these on hard copy paper, and you would have piles and piles of maps on which they're drawn in, and you've got to somehow index those and find those. And imagine a water master out in the field trying to decide if that field is getting the water it's supposed to get. Very, very difficult. Fast forward to today with GIS. You have a particular area. This happens to be an area on the Milk River in Montana. You can identify the fields. You can put in the irrigation canals and the turnouts. You can put in the fields that have water rights for irrigation with them. And then you can select a field and immediately link to the database that has that information. In Montana, when we started working with water users looking at these, of course it was before Google Earth. We're now used to the fact that everybody can look at our house and see our car parked out there, but when you first talk to farmers about this, oh my God, you know that's my house, you know that. But then when they started working on it, what I observed that this helped with was, first of all, if you sat down with a rancher or farmer with their legal land description and tried to say, we think you've claimed too much water, that's very threatening, because how do you figure out if that's true? But if you sit down with a map like this and say, look, these are your fields, right? And these are ones you're irrigating, and now you claimed water over here, which is actually the field that you're not using. And immediately they could see that what you're suggesting as the change, the reduction in their water right, actually still satisfies exactly what they want to do. It became much easier to resolve these disputes. And as was talked about the other day, this also allows information sharing and the various parties to be developing this information together, which immediately sets you with a base for moving forward. The other thing it does is makes it much easier than when we get to the implementation phase of these settlements to be able to handle the information and manage where the water goes in. We've heard over and over again throughout yesterday and today about the importance of dialogue, and I will just emphasize that that's absolutely true. One thing that Jason didn't mention before I came into my third career as a law professor, I was a negotiator for the state of Montana, negotiating reserve water rights, and in 10 years I did 10 settlements, 2 tribal and the rest for federal reserved lands. And we really learned a lot about dialogue in that process. And a couple things that I would say, I agree with Amy before that these dialogues have to have the stamp of approval and the support and the funding from the 3 sovereigns. It has to be sovereign to sovereign, government to government, state, federal, tribal. But at the same time, what we heard about the Ray Canal District, the solutions are going to come from the people that are using the water. And what the people, the state, federal, tribal representatives that are at the governmental level need to do is facilitate that and bring that together. And then as it starts to move along, step back and let it happen. It's the people that use the water that really need to come up with these settlements. And what I think we heard from the last panel is at first some sort of regret, or at least I felt that the Bighorn adjudication was the opportunity to begin that dialogue, to talk about things like in-stream flows, to talk about things like development in the face of climate change. And you didn't use that opportunity, it sounds like. But what I want to say to you is that is not the last opportunity. You now have a definition of those water rights. Now you can move forward with that dialogue. You still have the leverage of the future water rights that the tribe holds, and you still have sort of the threat of continued drought, climate change to bring people together. So you have the starting point now to begin that dialogue and move forward. Just briefly on cost and finality, these are expensive. You have to go into it with the will to fund that technology that I talked about, the dialogue, use of facilitators, people to help bring people together around this. And these are not final. They are only the recording of the water rights. You still have to manage them. You still have to respond to drought. You still have to decide what you're going to do when you have trouble with your fisheries. It's only the basis on which the real solutions are to be built. So I'm going to turn it over to Burke with one of the big questions, is adjudication always the answer?
I'd like to echo the thanks of the panel to the tribes and to the University of Wyoming for bringing us all out here. It's a real honor to present in this place before this audience. In Kansas, we do have some tribal reserved rights we're working through. They're not nearly of this scope. They're in much wetter areas. But we do have a reserve water rights settlement we're working through in the Kickapoo tribe. And it is the usual litany of broken promises and cowardice by the federal government. It has an 1832 water right, which is somewhat fascinating because Kansas wasn't a territory until the Kansas-Nebraska Act. And the reason it has that is because the Kickapoo were originally in Missouri. And so the treaty that establishes their right is a Missouri treaty, and then they were relocated to Kansas. As Jason said, I come to this with various either principled biases or biased principles, depending on how you want to think about it. Mostly they come from litigation. I get paid to sue the state of Nebraska. I'm the happiest lawyer in Kansas as a result. This litigation has sort of ruled my life for the last 6 years, and so I may occasionally veer into editorializing. These are my opinions, not the state of Kansas's. I'm also a recovering historian, so I tend to view these things with an historical view and stress the context. And finally, I'm very concerned about the Ogallala Aquifer, which is the largest freshwater supply in the United States. It's being permanently depleted at a rapidly increasing rate. About every 2 years, we deplete the Ogallala by a volume equal to the total volume of the waters of the Colorado River Basin. So I've been put here by Jason as a dare. How can you make the Bighorn adjudication applicable to the Ogallala? And I'm going to first try and deflect that question a little bit, like any lawyer would. But it does raise some comparisons. I think it raises some comparisons between tribal water rights adjudications and interstate water conflicts. As we've known from much more knowledgeable people in this conference, you have the Winters case, which established reserved water rights, at least on paper, back in 1908. And there's a gap of decades between this legal right on paper and the actual effect of having wet water on tribal lands. Interstate conflicts originate around the same period. The conflicts on the Rio Grande, between New Mexico and Texas, conflicts between Kansas and Colorado on the Arkansas River. They're turn of the 20th century conflicts, and they promote eventually interstate compacts, starting with the New Deal, the 1930s and the 1940s. And a central partner in these intrastate compacts is the federal government. The federal government quite sensibly wanted to know how much water the states would ask for these reclamation projects. They wanted these rights quantified by the respective states. And this forced a series of legal crises across various Great Plains states to make sure they had the water codes necessary to quantify their rights. So for example, Kansas revolutionized its water right code to incorporate groundwater. Nebraska did fairly effective adjudication of all of its surface rights. So what you see during the 1930s and the 40s is an integration of the law of interstate compacts, adjudicating rights between states, and federal law of reclamation. How are reclamations projects going to be affected in a permanent and sustainable way? This was an intentional cross-fertilization between the two bodies of federal law. But as we've seen at this conference, developments in the 1950s forced a crisis across the West. We've discussed the McKinnon Amendment. We've discussed slightly, I'd refer to John Thorson and Ramsey Kropp's article, two-part article in the University of Denver Water Law Review, a very ambitious survey of all of these adjudications. They summarize how federal Indian policy changed under the Truman and Eisenhower administrations in a very damaging way. So the 1950s forced a crisis in tribal water rights and tribal rights generally. The 1950s also turned the world of Western water totally upside down because of the groundwater revolution. With the development of high-capacity centrifugal pumps to irrigate the Ogallala, what's in blue on that map was almost exclusively dry land farming before the 1950s. And so the increase in groundwater depletion changed the political calculus across this region. Nebraska had developed by about 1970 1 million acres of surface irrigation, largely through reclamation and other projects, but that has been dwarfed by the amount of groundwater irrigation under development there, about 7 million acres. So you have a ratio of 7 to 1 groundwater to surface. Kansas is no different. 90 to 85% of the water in Kansas goes to agriculture, and about 80 to 85% of that comes from the ground, primarily the Ogallala. So starting in the 1970s, you have a new era of interstate water conflicts, and it has to do with the depletion of the water supplies in these basins as a result of groundwater pumping. So you have litigation on the Pecos River between New Mexico and Texas. You have litigation between Kansas and Colorado on the Arkansas River and on the Republican River. That's not named because there are only Republicans in the basin, by the way. It's a Republican river. It runs parallel to the Platte, just inside the Nebraska line. It's because when white Americans were going west and surveying these lands, they thought the tribes in this basin had particularly great civic virtues, that these were Republican Indians that could be civilized into the American Republic more easily. So this doesn't have to be a partisan conflict. It's a water conflict. But on the surface, these interstate suits are suits between states, right? But beneath the surface, there's something more serious going on. This is a conflict between surface water users and groundwater users. And in some cases, the blunt instrument of interstate water litigation did force some sort of compromise and balance between these two parties. For example, in the state of Colorado, Kansas's partial victory in that case enabled a reduction of excessive groundwater pumping, reductions that the Colorado State Engineer had sought to protect surface users in the Arkansas River Basin, but that the courts of Colorado had not really allowed him to do. So the blunt weapon of a Supreme Court decision gave the state engineer clearance to do that. So across the basin, you have this incipient conflict between groundwater and surface water users. And this brings me to the second comparison with the Bighorn, and that is the problem of legal diversity. Let me give you a scary map. This is the extent of the High Plains Ogallala Aquifer. The western edge, it's less rechargeable. The eastern edge, it's somewhat rechargeable. And this is the one that should scare people, especially in Kansas. This is a Kansas-specific map. The darker the color, the faster and more serious the depletion is. So there are pockets of recharge in the east and the northwest, but I don't really trust the northwest pieces of blue. I think that is an anomaly from this graph. But if you think about the Bighorn process, it wrestled with distinct types of water rights. Reserved water rights for the tribes, reserved water rights for federal lands, other federal rights under state law rights. In the Ogallala states, you have a difficult diversity as well. Some states have segregated legal regimes for water. Nebraska, for example, follows the doctrine of prior appropriation for surface water, but it follows the doctrine of correlative rights for groundwater. Also, it's a jurisdictional split. The state engineer controls the surface water rights, as he has since statehood, roughly, but local districts, known as natural resource districts, make decisions regarding groundwater pumping. So there are differences in the substantive law and in the jurisdictions about who controls which water supply. Kansas brags about how wonderful its water law is. This sort of puts a lie to how great the law is working if we are running out of water at this fast a pace. But it does have a more integrated system. Oklahoma is more like Nebraska's. It's more bifurcated. And what this is doing, I think, is putting all of the states and the federal government in a very difficult situation across the Ogallala. Surface rights are prior appropriation rights. They've largely been adjudicated in Nebraska and Kansas and Oklahoma. But groundwater rights, not necessarily, as I said. And so in dry years, you can get some pretty difficult situations in this part of the country. Groundwater pumpers are more powerful than surface water irrigators across this region. And so what you have in a situation of an interstate conflict where there is a water short situation, the state may use its central authority to actually shut down the oldest rights that are surface rights so that that water can be shepherded downstream to honor downstream interstate compact obligations, enabling the more powerful groundwater interests in that state to pump more groundwater. So it's a case of first in time, last in rights. And if any of you tribal people out there know that, you know that very well, okay? Having really old paper rights, but not necessarily being able to affect them. And building on some of the comments from yesterday, the juniors, the groundwater pumpers, are not eager to have all of these rights adjudicated. So in light of this groundwater revolution and this problem of legal diversity, is adjudication the answer? I think it is. I don't know how. I will defer to Larry, I'll defer to Barb and Michelle and Jason about this, but I do have at least some closing thoughts. The most important problem here is the reality of permanent depletion. The Wind River flows more in wet years and less in dry years, but it is, generally speaking, a sustainable water supply. This is not a sustainable water supply as we are currently using it. It could not be a sustainable water supply. But what I think we need to do is we need to have a reckoning about the groundwater revolution. That if you have too many water rights for not enough water, that's the context in which adjudications have to take place. And it's a looming problem for the states, especially when, for interstate compact purposes, to replace water that would otherwise flow to the stream, they are accessing deeper groundwater formations to transplant that water, and through the magic of Western water law, Ogallala groundwater piped to the surface becomes surface water. That's a long-term solution for states. I don't know how sustainable it is out more than 20 or 30 years. So I think there's a need for a reckoning. Barb has mentioned the administrative tools for quantifying rights. We've seen a lot of good stuff about that this last 2 days. But I think across the West, the High Plains and Great Plains states, this problem of legal segregation is a real problem. And it puts Reclamation in a tough spot. They run projects across interstate basins. How are they going to protect their projects given that some states protect surface water rights differently than other rights? So I think you can no more divide the legal regimes of interstate compacts from the federal law of reclamation than you can divide surface water from groundwater. And to paraphrase Professor McDonald's book, how do you get from the ambitions of reclamation to the goal of sustainability? It's going to be a tough problem, but I think in closing it will probably take something like an adjudication where the federal government is going to have to give a concrete position and take a leadership role that would greatly benefit the states. Thank you.
What an incredible breadth of knowledge and experience. Barb, Burke, Larry. We also have, in this case, time for 1 or 2 comments by co-panelists. Larry, Michelle, any takers as far as the material covered by Professor Cosens or Professor Griggs? Okay. If not, we can allocate that time toward open audience Q&A, maybe have a little bit more at the back end. Does that sound good? Okay. We will then move forward to the third speaker. Again, Professor Michelle Bryan from U of M. She'll address the third question I mentioned at the outset.
I'll join the other panelists in expressing my gratitude to our hosts from the tribes and the University of Wyoming, and Jason in particular, for reaching out and inviting me. I teach water law at the University of Montana, and I grew up on the Milk River between the Fort Belknap and the Rocky Boy Indian reservations, and my family homesteaded there. And it's this place where the Winters Doctrine arises. So I grew up thinking about how important water is, and Barb and I were talking earlier, what makes water people so amazing? Because I just delight in spending time with water people, and I think part of it is that we love water and we want to figure out. We want to always trying to figure out a little bit more. Part of my work at the university is that I run a clinic with students in their final year of law school who, along with me, work for government in trying to figure out on different natural resource legal questions. One of my former clinic students is now a water master with the water court. This last year, what we were figuring out was a question that the water court in the state of Montana and our state agency, which is called the Department of Natural Resources and Conservation. It's a question they posed: what do we look like after adjudication? Can we have a living decree that keeps reflecting the changes that happen to our water over time? And so we undertook a study where we looked at the way Montana's legal systems work, but we also were asked by the Chief Justice of the Supreme Court, who commissioned the work, to look at other Western states as well. So I spent a year, along with my students, talking to water judges, agency directors, Department of Justice lawyers, and seasoned private practitioners. Very delightful project that keeps going, and I want to share pieces of that with you today. And it talks, it speaks to the third question: how is adjudication relevant to water management? Because what the parties really wanted to think about is how do we take what we're doing in adjudication and make it relate to the way agencies review changes to water rights? And how do we relate it to, on the ground, the way decrees are implemented by, some states call them water commissioners, some states call them water masters, but those people on the ground who are delivering water. And so my conclusion is that adjudication leads to a lot of new clarity. We get defined characteristics about our water rights, but then it also opens up a whole new universe of questions when we get to implementation. A huge question, which I think Burke alluded to a little bit, is even if we know all of the priority dates and the characteristics of the waters, historically we've often been very localized. And now we're doing these huge basin-wide decrees. So how does the rights on one local creek relate to the rights on an upstream tributary that's been locally managed, and now we're integrating them all in a basin-wide way? And how do we know the relationship between the surface and the groundwater, even in places that adjudicate both, like Montana and Idaho? And there was a study that came out of one of our major basins, the Clark Fork River Basin. And it says, adjudication ties together and creates new relationships among water rights, new relationships that may not have been recognized before. And they give an example in the Clark Fork River, which holds, I think they say 22,000 acre-feet of water. Historically, Montana water was often developed first in the lower places on a watershed. A senior right in a local area, such as Upper Flint Creek Valley, may therefore suddenly be junior to a right located downstream on Lower Flint Creek or on the main stem of the Clark Fork River. The Clark Fork River Basin is a significant part of the Confederated Salish and Kootenai compacting process as well because of their off-reservation in-stream flow. So folding those rights in as well, lots of new relationships, no longer localized, very large basin. How do we implement that? We don't yet have all the science to figure out when someone might be injuring another user and their water should be cut off. Then if we add in-stream flow, and how many of our historic diversionary rights are being converted to in-stream flows, or tribal rights for in-stream flows in those compacts where it has been recognized, how do we implement that on the ground? The other big area is records. And throughout my interviews with different state agencies and courts, what I discovered is that even though we have a lot of new great detail and clarity, the records are really still quite a mess. I asked the question over and over again, if I am a lawyer and I represent someone who wants to get a water right, where do I look to find out information about that water right? And in every state other than Colorado, the answer was here and here and here and here, and oh yeah, over there also. And so as a lawyer, it's really, or as a water rights holder, it's really hard to still go to a one-stop location to understand what is the water right. In most states, decrees are not going to be updated once they are finally issued. So there might be a decree that becomes less relevant over time, and then an agency might have permit information in another location, and then there might be maps and tabulations of local distribution systems in another location still. If there's a dispute in district court, there might be an order about a couple of water rates. You have to go to that district court to get it. So the record system is really still in need of work as these decrees come out. And then there are all these changes to water rates that never undergo agency review. Larry's written about this to a great extent. When you change your crops, when you change your diversion works, when you change your irrigation method, and there is no agency review, how do we know about that change to the water right? So those are some big questions that the adjudication, even though it gives us clarity, there's still a gap there to get to a place where we can implement and manage that decree. And the other big question is, what do we do with these water judges and in some cases even special water courts like Montana has? Once decrees are issued, what do we do with that expertise? How can we leverage that into the future? Good. Oh, good, good. Okay. So I posed these questions to experts and water users around the West, and I'm just compiling information on different things that places are trying that I think are really remarkable. They're not always working, but that's the thing with water ideas, is you have to put them out there, try them, and refine them. And I wanted to just share some of the ideas I've heard. It'll probably feel a little bit like I'm firing a lot at you at once, so I'll try to control myself. It's very exciting to hear some of these stories. I interviewed a water judge in Montana who does something called water walks. And she holds them every summer, and she has the water commissioner, the agency field office person who does the technical work, the water judge, the water users, walk the whole length of all the diversion works together to have a better understanding of the hydrology of that particular area that's under a decree under her control. And to talk about issues and questions. So it's just a good example of the collaboration that I think people have expressed during this talk that is so important. But I love the idea of a water walk. I think they even go on a picnic and do some other things together, but they do that every year. And it's really helped reduce the tension and the litigation in her particular district. In California, I'm going to throw out some states we haven't talked much about, but in California, they even have a water commissioner that's an entity. It's a group of people. And they've added other things that that person, that role fulfills, including commissioning studies and undertaking funding for projects to make areas that are subject to a decree work better. So there's some states that have sort of taken the traditional, like in Montana, there's sort of, the statutes read like they're kind of like a sheriff. They have the right to carry a gun and walk the ditch. And some states have taken that role and expanded it a little bit. My students are laughing because I get excited in class when I talk about water commissioners and their weapons. In Oregon, water commissioners get to do inspections and report back on the health of the diversion works. They get to issue violation citations, and they're involved in permit review and gathering data. Colorado, I think, is leveraging technology really well, and they've organized their commissioners really well. 7 major basins following their decrees. Decrees which, by the way, are updated on a monthly basis. And then they nest within those basins the local water districts. They use remote sensing and real-time data so that an upper river and a lower river commissioner are working together to turn on and shut off the water. So that technology really is pivotal, as Barb was pointing out. New Mexico is using more sophisticated surveys and doing modeling and looking at, is what we decreed actually sustainable and realistic when we go to deliver it. So those are some interesting examples, along with metering and reporting requirements. As I mentioned, with records, Colorado really is a leader. They're implementing the living decree with these monthly rolling updates that integrate not only the decreed rights, but changes and new permits. Everywhere else, you really have to look separately for records. A very tricky question is, how do we take the information in a decree and then process a change review in a separate change process? And a lot of the decrees are missing vital information, like in Montana in particular, no volume. And as Patrick Tyrrell mentioned earlier, without knowing if someone's injured, we can't really approve a change. And so there's still a disconnect where decrees need to get more detailed. And New Mexico, for example, has started decreeing consumption right in the decree so that they fast track their change process, and they're doing a consumptive irrigation requirement and a farm delivery requirement right in their decrees. What are these water courts and water judges going to do post-decree? Idaho, you've heard about, has finished its decree, and it also made the SRBA court permanent to hear appeals and appeals from agency permitting decisions and water disputes going forward. Leveraging that expertise and the resources that are already existing. And some other states also, Nevada, Utah, California, and Arizona, allow their courts to retain ongoing jurisdiction and continue to play a role in the disputes with which they're already familiar. So those are some of the ways I think that states are trying to bridge that gap between the details of the decree and actually implementing it on the ground. And I think the result of our work is going to be a study bill in Montana, looking further at how Montana can adapt its system to make the post-decree world really effective for our water rights holders.
All right, thank you very much, Michelle. Are general streams adjudications relevant to future Western water management? Exactly what role will they play? The question she addressed. In line with how we've proceeded so far, I'll ask co-panelists, do you have thoughts that were prompted by Michelle's remarks or otherwise related to this question? Burke? Larry? All right, Larry.
I think what we understand about the need for clarification of who has the right to do what is a starting point. And it's essential. We have to have those records. We have to have that all very clear. But it is only that. It only creates this, legal record of title to the use of water. That's the beginning. The real work and what happens out on the ground is almost sometimes completely different than what a piece of paper in an office might say. Water management then talks about the kinds of things we were just talking about with that earlier panel. How do we really accomplish what it is we want as a community, as users of a shared resource? That's a different discussion. We begin understanding that people hold these pieces of paper, and we have to, acknowledge that they have the facial right to the use of that water. But that's only a starting point. So we get that starting point in hand, and then I think we sit down and we really figure out what we'd like. And I think there's no barriers to any possibility that we can agree to among ourselves.
Thank you very much, Larry. Burke, Barb, want to chime in? All right.
I would probably just echo Larry's comments and push it in the direction of lawyers should not get as hung up on the statutory code of what these water rights are. That is largely a static definition. And a good, again, contrast would be the state of Kansas, which has this integrated groundwater and surface water legal regime, but protects and administers these different types of water rights very differently. And that administration has made the state vulnerable, I think, to legal attack and to criticism. So I think Larry's point about how the law is used by the state is a very important point. It's not just the law in the books. And secondly, how the water rights owners themselves use the water. They are usually much better at figuring out a way to meet a certain target of use, whether it's gross use, consumptive use, or other quantification of use, than the state engineer, who would come in, usually viewed as a foreigner, in a hostile environment where people think they're going to all get cut. And if there is local initiative to frame the response, in my experience representing the Kansas state engineer, he has welcomed that. It has accelerated the resolution.
Now, Barb, I can give you a pass because you chimed in on the first question. Should I do that? All right.
Yeah, that's fine.
All right. This panel, I think, is the personification of Frank Crow. Who is Frank Crow? Chief engineer responsible for construction of Hoover Dam, built it on time, under budget, and that's how we roll up here. I have 15 minutes built in for open audience Q&A. Many meaningful remarks were offered in the previous panel about capacity building and how education is a dimension of that. You have a proverbial, not only Frank Crow, but brain trust up here of individuals with practical and scholarly expertise in Western water law and policy. What questions might you have for them related to general stream adjudication, settlements, other aspects of the field implicated by the Bighorn and its counterparts throughout the West? My colleague Deb Donahue has a microphone to take questions. Yeah, we have some time for this. Please speak up. Mr. Thorson, John.
Thank you. A very excellent panel discussion. We have given a lot of attention to the McCarran Amendment and the waiver of federal sovereign immunity for the adjudication of reserved water rights. We haven't talked much about another aspect of the McCarran Amendment, which is the sovereign waiver for suits concerning the administration of those rights when the U.S. is a necessary party. And I'm just wondering how the panel sees that aspect of McCarran requiring some ongoing issues or future issues to be addressed in court rather than before agencies.
Thank you very much. Panelists who'd like to respond to that very thoughtful question, the McCarran Amendment's relevance to future administration. Takers? Yeah.
This is a sideways thought that came up in some of the interviews I did in some of the states that aren't doing comprehensive state adjudication, and they are adjudicating tribal rights in federal court. Those states indicated that the only administration that's going on right now through water commissioners is through those federal court decrees. So they've appreciated the federal component, but it leaves open a huge question of how do those court-ordered commissioners from the federal courts work alongside the state commissioners when those states get to a place where they also have their state adjudications rolling. And it does seem like it could be a bit of a conundrum without some sort of cooperative agreement with the federal district courts and the state water judges that are issuing decrees.
Thank you, Michelle. Other panelists who might be interested in responding? Barb? Thank you very much.
Another way that that's been handled, again, I'll sound like a broken record, but is through settlement. So in a number of the settlements, administration has been worked out. So in some of the ones I worked in Montana, one that has never been approved by Congress yet or completed, but for Fort Belknap, which was the Winters, the home of the Winters case, they share the Milk River with several other reservations and a Bureau of Reclamation project, and is set up not only administration within the reservation boundaries under a tribal water code, a process for coordinating that with state administration of water rights off the reservation so that there's opportunities on both sides to object to new water rights or to changes in use. But also would have established a commission that would have both tribal and irrigation district representation for the management of the entire Milk River. And so I think there are ways that settlement can avoid the issue of piecemeal jurisdiction and piecemeal management of the water after adjudication.
Great. Larry, Burke, would you like to add? Burke?
Responding to your question, John, but also to Amy Cordalis's point, her recommendation that there be, a joint coordination commission to resolve some of these. That is a possibility. One of the things in interstate relations is you have compact administrations, and it's their job to administer the compact. And where there's been litigation, at least on the Kansas side, you have very long settlement documents. And it is the compact administration's job to make sense of that settlement document and to work within its limits. And the settlements are imperfect. They don't anticipate the future. And so I think the jury is out on how well, at least in many interstate basins, these joint commissions are working. But I take hope in what Montana is doing with its tribal compact. I think that procedure strikes me as an excellent vehicle through which to work through some of these federal problems.
Larry, would you like to add? All right. We have time for at least 2 more questions. Again, please take advantage of the fact that we have all these experts in the room. Mr. Chafin in the back there. Oh, pardon me, sir.
Good morning, Wes Martell. Been sitting in here, kind of had some other things go on, so I wasn't able to sit in on all of the presentations. And as somebody that's been dealing with this water issue, I first got on the council in 1979. And 1977 was when the state of Wyoming drug us into court. And violated their own constitution to do that. This is really hard to listen to a lot of this for me, because to me it's the same old status quo. You Indians here at Wind River, the court stole 2/3 of your water. Be happy, enjoy it, talk. This is really an onslaught against tribal sovereignty and treaty rights. And unfortunately, we're still pushing that same old colonialistic, Christian dominance kind of theory that we know what's best for you Indians. But it's really hard for us to justify how can you not have a reserved right to groundwater. That's nuts. And when we're talking about all these issues, talking about the Ogallala Aquifer and these interstate compacts, how come tribes aren't at the table in those discussions? So I'm really thankful for all this information that's going out. Sure wish more of our tribal people were here, but sure wish more of our tribal leaders would get up and speak for us, but that's not going to happen right now. And my question to this is, when you've got Bureau of Reclamation saying that they cannot recognize tribal water codes because of Section 8 of the Reclamation Act, how do you deal with those kinds of issues when you're trying to protect your own treaty rights and your own sovereignty and your own people? How do you justify not having a reserved right to groundwater? That's my main question.
Thank you very much, Mr. Martell. Comments on that question or other aspects of Mr. Martell's remarks? Barb Cosens?
So the groundwater issue has been a big issue across the West because the only pronouncement we have from the U.S. Supreme Court is the Caper case, which is a federal reservation, not a Native American reservation, and many of us feel that the narrow standard for federal reservations is not the standard that should apply to Native American reservations. But that case ducked the issue of groundwater and simply said that if a surface, even though it within a cave, pond was being affected by groundwater pumping, the United States could seek an injunction against that groundwater pumping. So otherwise, we have this situation that Larry had pointed out and that you raised, that different states have treated groundwater differently. One way you might think of it is it really over on groundwater? I know the state's going to run me out of Wyoming after I say this, but when this issue came up for Wyoming, you usually find in negotiations that your hardest negotiations are your internal negotiations, and the state of Montana, all of our stuff's a matter of public record, so I can disclose all of this, said, well, the Supreme Court hasn't said we recognize a reserve right to groundwater, so we don't have to recognize. And I said, well, and when I teach groundwater to students, I say this, there are 4 different ways that states handle groundwater, and you heard about them in Burke's talk. You know, it can be because you own the land above, you have the right to all the groundwater, whether or not it affects your neighbor to pump it or not, or you can have correlative rights that are proportional to the land you own, or you can have reasonable use, which is very much like a riparian right, or you can manage it by prior appropriation. Federal law determines what the water right is for a Native American reservation, not state law. And therefore, what I said to the commission is you can go ahead and say we won't negotiate groundwater, but just wait till the court case that decides, maybe 25% chance that it will, that the tribe owns by virtue of having the land above, has all of the water below and can use it as much as they want. And so I think a refusal to look at that as a reserved water right, it may still be a property right. And I think that tribes can still pursue that and take a look at it in going forward. Maybe again, another leverage point for dialogue.
All right. Michelle, did you want to add to that?
Well, I just cite to the example of the yet legislatively approved Confederated and Salish Kootenai Compact, which I think is a really innovative compact in that it actually has a joint water code for surface groundwater and off-stream flows between the tribes, the federal government, which has a BIA project, and the state, where they're going to, it's one code for permitting of groundwater and surface water, implementation and enforcement, and it's a negotiated water code. And I'm pretty impressed with what they got done. I hope our legislature takes another look at it again.
Thank you very much. We've had a question in the back since the beginning. Mr. Chafin at the solicitor's office.
I don't know if I'll need that or not.
Well, your voice projects pretty well, but for good measure, why not?
My question goes, it was raised yesterday in the Wyoming adjudication, where there are some rights, if I remember right, that are decreed in acre feet, and then others are decreed in a flow rate. And I know with all of the compacts in Montana, there is at least a portion that it is solely decreed in an acre foot, in a volume. How easy or how hard is it going to be to break that acre foot decree down into a flow rate so that that can be administered in the future?
Very practical question. Panelists, thoughts on that? Conversion of acre feet into a practicable flow rate.
I have no idea. I would turn it the other way around. How can you turn CFS into acre feet, and then you meter that acre feet, and once you're at your acre foot level, you're done? I mean, I think it would be much harder to go the other way. Kansas is an acre foot state. Colorado is a CFS state. And I struggle when we work with Colorado on the Arkansas River. We're looking at Arkansas River decrees that are in CFS, converting these to the Kansas measurements on the ditches on the Ark. In Kansas, you have to try and do this. And so, once again, I'm totally defying the premise of your question. I'm thinking maybe we should go the other way around. It seems easier, but I'm not a technical person.
Other thoughts on that question? Barb?
It seems like, well, two things on that. One is, I guess, what that points to is the lessons going forward is that any new adjudication that's filed, they might want to look at having a little bit more uniformity in how they decree their rights. And I think the example that Michelle pointed out from New Mexico, where they're starting to decree rights in terms of consumptive use, is a great one. It would have avoided Montana versus Wyoming. Having said that, it's really a technical issue, and we now have the technical capability to do the kind of measurement that you can know what the flow rate is in real time, can know what's being delivered in real time, and I think in many ways it breaks down to putting the funding into implementation and doing the metering in order to track those water uses.
Yet again, we return to the topic of technology. Any input from Larry or Michelle? If not, I will conclude this final panel. It's about 11:45. For those who purchased lunch tickets, the buffet line is being set up. Please get in line and enjoy. We'll reconvene at 1 p.m. for closing remarks by the member of the Wyoming Judiciary who's been more involved in this adjudication for a longer period of time than any other, Judge Gary Hartman. So I will see you at 1 o'clock. Thank you.
I'd love to know kind of what you're currently doing, but I need to get more background on what you have.
Sure. Well, maybe we should talk on the phone, or I come to Colorado pretty regularly. Are you there now, or are you in Wyoming? Yeah. The short answer is I was the chief lawyer for the Department of Agriculture in Kansas, and then due to political issues that I won't bore you with, I saw that it would be better to be at the Attorney General's office during this Nebraska litigation. So I do the 4 interstate compact Kansas has, and then the Nebraska litigation, but also relations with Colorado on the Ark, which is an ongoing, technical challenge. And the settlement in the Nebraska case has an arbitration provision. And so we've been arbitrating our tail off. We did 5 arbitrations this year. I lost half of my hair. I gained. So in the middle of all this, after we went to trial in Nebraska on the Republican case, that was 2012. And then last year, I was at Stanford at the Bill Lane Center. And they have this wonderful thing that we need to rope you in on. It's the Lane Center, named after the founder of Sunset Magazine. He gave a ton of money. Yeah, that's it. Yeah, that's Bill Lane. And so and then there's the Lane Center, and then there's the center that Buzz Thompson basically co-founded, the Woods Institute for the Environment. They have a joint project called Water in the West. So they brought me out for a year to be this visiting guy to work on groundwater, because you've seen that the California Assembly passing this groundwater legislation. And you want some angry rooms, man. I talked about groundwater swimmers, like full-on California corporate irrigation interests. But to their credit, they kind of knew it was coming. So they want to shape the terrain, right? Well, and it's a local initiative. If you don't do it, we'll come in and do it for you. So that was last year.
Critical areas, so it's not everybody.
Right.
I mean, they took a nice sort of beginning step that I think will broaden.
Right. So last year, that was that, and then I came back to wrap up the Republican case. We're in front of the court in about 3 weeks, about a month actually. And then I think my time with the state may be limited. I might move on to other things. So I put my hat in the ring on the academic job market, but I know that it's a terrible time. But what we have is we have all this interest in water, not as much interest in water law jobs or law jobs. So I'm not wedded to that, but I want to be able to do the most interesting things I can in water, and I've been very lucky so far with this litigation. So that's my
pretty major issues that you've been very front and center on. Good. Well, good. Well, yeah. By all means, you know.
Yeah.
I mean, you have my email.
I know how to find you, and I had a nice talk with Phil Weiser actually.
Oh, you did? Okay.
A former colleague of yours who's now in the Supreme Court of Colorado. She said you should call Phil, and I had a nice chat with Phil, and he talked to me about the Getches Center. Talked to it about with Brad Udall, who came out to Stanford occasionally. You know, that's there are reasons. I don't know, but everything's evolving, and if I were a law dean, I'd be scared as hell. You know? So,
it has a lot of potential.
It does. It does. And being at the Woods Institute and being at the Lane Center and seeing what Buzz is doing with the water in the West, you know, I think there's potential. I think it's a good model. We should get you. Well, he's slammed, but he's a special guest.
Of course, yeah.
He takes
on. Waiting for that decision. Come on.
Yeah. So that's where we are. Yeah.
It's you know, very nice. It's a little belated, but
it's okay. It's okay. It's my fault, not yours.
No, not at all.
So what are you doing? I mean, you're. Tell me.
You know, doing what I can do.
Really, you're kayaking.
You know, doing some writing stuff. You know, just finished a big piece that's out there in the world.
Right on this. Yeah.
So that's, you know, it's become a little more challenging than I thought when I got into it.
You always do.
Ladies and gentlemen, I have gotten a couple questions about checkout for those who are staying in the facility. You'll want to do that now. Checkout time is noon. The good news is there's a bellhop room adjacent to the front desk where you can keep your stuff. Bring your luggage and so forth up there. They'll give you a ticket just as if you were checking a coat.
I'll look you up. I'll buy you lunch. Sure. It'd be great.
I'd love to do that. Then, you know, I mean, I'm sort of a little bit on the margins involved with the Senator's house.
Right.
Looking into what possibilities there might be.
Okay. And another good guy to talk to, he's not going anywhere because his wife's the dean at Stanford. His name's Leon Sheptisky. I don't know if you've ever worked with him. He's former GC for Trout. And so one of the things he's doing with the Woods Institute is, you know, with Buzz interests in water market. How do you spend money intelligently for instrument flow restoration? Say the Wyoming Conservancy gets you $3 million, but you can waste that pretty easily if you don't know meteorology, if you don't know the system of water rights restoration. So that's what I really liked about the year was how practical focused. Well, and I hope CU goes that way.
Well,
you know, I really do.
But, you know, they have a history of network for one. We did a lot of policy stuff.
Right.
Everything sort of got a little chaotic, and now they're trying to reformulate. I think this is a great time to look at new opportunities. Big mark. So You know, that's what we need to do. We need to look at, you know, if there's someone like you out there who's really could bring something.
I'm assuming it's right.
Good, all right. Well,
no, this is great. Are you going to stay for lunch? You take it?
Yeah. I'm going to catch up with this lady over here. We haven't had a chance to get some time to catch up.
Appreciate your time.
Yeah.
That's kind of what I was thinking in my head.
Okay.
I don't know. Like this, honestly, like just kind of came out. So I didn't even know I was going.
So I think,
Thank you for being nice, Mr. I know it. I didn't name names.
I know.
It's a tough spot. It's just a tough
Also, I just don't want to use my chip sparing myself. We'll see. If not this year, next year. All right.
similar to the way they do it. Or, you know, I think there's consensus to get. I know, I get it. I mean, in the sense of
Which one was working? This one?
They're fickle. I would, if we can get this one up, and this one's up too. So.
That one?
Maybe call people to order and give
All right, everyone, can we get your attention, please? Thanks, everyone, for hanging in this afternoon. The sun's out, the snow's on the mountains, and it's Friday afternoon. It gives me great pleasure, and it is a true honor to be the person asked to introduce our closing keynote speaker. The Honorable, I call him Judge Hartman, but he actually, at this point in his life, serves as the Senior Policy Advisor to Governor Matt Mead. And he's worked for the governor's office in both juvenile matters and in military matters. And he served for for Governor Freudenthal as well, Governor Dave. But before that, he was the Bighorn River adjudication judge for as long as I've known him, and he hired me as the special master. He's been a mentor, a teacher, a colleague, a friend, and all those things over again to me as I've learned and grown through this process and how we tried to move this forward in a positive and judicial way for all the various parties' interests. So Judge Hartman has been talking to a lot of different people and thinking about closing remarks for this discussion, and if you could please join me in welcoming him to our session.
Well, thank you, Ramsey. It certainly is my pleasure to be here with you this afternoon to deliver some closing remarks. I would like to also thank the tribes, the University Law School, for putting on this symposium. I think this has been a fantastic thing. I'm very surprised at how well it was attended. The information I had about a week and a half ago was that, well, maybe there'll be 75. I think that was underestimated by about 100. At any rate, let me give you a little bit of background. I practiced law up in the Bighorn Basin, and all of a sudden I had some people showing up in my office saying, we don't know what this is, but we got notification of some kind of a river adjudication. Do you know what this is about? Heck no, I don't know what it's about. So we began to look at this thing, and as it turned out, this was in response to about 20,000 notices sent out when this case got started in 1977. So on behalf of some clients, I filed some answers in the particular case. Later, I thought, when I became a judge, that my previous involvement with some irrigators might be sufficient to disqualify me. I made disclosures to the attorneys. They said, oh, no, that's not going to get you out. You're in. At any rate, it was my pleasure to serve in that capacity for about 22 years. I'd like to make some comments here this afternoon. I've sat in on some of the discussions, some of the panels. Very, very interesting, a lot of issues that have arisen and certainly are in need of some further work. I guess I'd like to start by asking you, why are you here? Why are you here? Well, I think there's a couple of reasons. I think number one, I think you're here because you want to learn something more about general stream adjudication. You have an interest, you're working in the field, you have a potential to work in that field of stream adjudication, and it is a very complex issue. I think that's one reason. I think there's a second reason you're here. I think you're here because you want to get your battery recharged. You work in this field, you're working with permits, you're working with legal descriptions, you're working with priority dates day in, day out. Sometimes that gets to be rather onerous. And so you can come together at a symposium like this to meet up with other people who are doing some of the same things you are doing, and you also have the ability to get some ideas from those folks and to establish that relationship that when you encounter something, you can pick up the phone and say, hey, remember me? I sat next to you at the dinner at the symposium. I've got a problem here that maybe you can help me with. That's a very, very, very significant thing. Well, I know during the course of this symposium, you've heard a lot of talk about economic benefits of stream adjudication. I think you've heard a lot about how the Ray Canal came into being and what some of those issues are, as well as some of the other presenters who've made some excellent comments and remarks. One thing that I understand was touched on very briefly, and that is what was called back in my day, dividing the waters. That was a compilation of district judges, of special masters, of referees who were working on stream adjudications in the western part of the United States. We were successful in getting some money to bring these people together to start having much as what's been going on right here, a symposium. Well, dividing the waters became a huge resource center with petitions, final orders, with other documents that were accessible to other people who were doing general stream adjudications. Very, very helpful. It has since changed. My understanding now is it's been taken over by the National Judicial College in Reno, Nevada. And they have a separate board of directors that handles dividing the water. But again, it's an excellent resource center. Well, last Friday, I flew up from Cheyenne to Worland to witness Judge Scar signing the final decree. That was a date that I'd waited for a long time, and I was hoping it would happen on my watch. We just didn't get it done. But at any rate, I think there's some good things that came out of that decree. Number one, certainly the water rights have been quantified on the Bighorn. Number two, the authority of the Board of Control has been restored back to that agency statutorily. They are the ones that adjudicate water permits in the state of Wyoming. But you know, I think there's a downside to that signing of the decree. And while we talked about what is that final order going to look like, one thing that was pretty predominant in that was a feeling that the court should retain jurisdiction, just in case somebody else discovers, hey, I might be a Walton right holder, but I need it decreed. I need to go back to court. So the door was left ajar. And I believe that the final decree says if a party petitions the court to resolve a dispute in the future, the court can accept it. But I think the downside of that is the court was left, in my estimation, without any jurisdiction to say, you know, I see something going on out here, I'm hearing something, let's bring the parties in, let's bring the tribes, let's bring the BIA, the BLM, the state engineer's office, and Middale, or whoever it might be, back in here to start talking about this issue, to say, ladies and gentlemen, I want you to conduct some settlement conferences to see if you can work this out. I don't think the court has jurisdiction to do that anymore. So I think that's a downside of what's happened when the final decree was signed. Well, I think there's some takeaways today, and that's what I'd like to do, is to give you some takeaways. I think there are 4 of them, at least that I can see. And I'll talk about each one of these separately. If you as a judge or special master or a referee or a potential irrigator or even a lawyer, I think these things are applicable to you. One of these takeaways, and one of my mistakes is, I think we needed to have a sound case management problem and plan for Bighorn. We didn't have it. All of a sudden, this elephant shows up in the room, and we're trying to eat this elephant one bite at a time. That's difficult. I think a second takeaway is that there needs to be communication by the parties. When I got into the case, the parties were so polarized that a particular party would sit in this part of the courtroom, another party would sit over here, and they didn't talk. How do you deal with something like that? I think a third takeaway is there has to be some transparency, and I'll go into that in a minute. And finally, I think another takeaway is there needs to be some certainty. So let me break these things down for you one by one. Let's talk about case management. Well, let me tell you a story. 2 moose hunters went up to northern Canada to go moose hunting. They hired a float plane to take them back into the remote areas. They had their guns, their ammo, their food supplies, and an adequate supply libation when they took off and left. So the float plane driver left them at the dock. He said, "I'll be back in 1 week to pick you up." But he said one word of warning: you have a moose permit, but I don't want you bringing back any moose expecting me to haul it out. Guess what? A week later he shows up, and there on the dock are the 2 hunters with their guns, what's left of their ammunition. Their libation is all gone, of course. And there's 600 pounds of moose meat, frozen and wrapped. Pilot jumps out, says, "I thought I told you I could not haul meat out of here." And one of the hunters said, "Well, the guy last year did." Pilot said, "Really? Well, okay, get it in here." So they loaded everything in the airplane. Pilot taxis way to the edge of the lake, begins the takeoff run, plane starts bouncing. They finally stagger into the air, barely clear the trees at the end of the lake, and guess what? They crash. And in the quiet, the 2 hunters, unscathed, sitting around looking at each other saying, "Well, at least we made it 100 yards further than we did last year." Well, that's not the kind of case management you want when you're trying to achieve an objective. Well, I think that there are some things that can be done. Number one, if you have an adequate case management plan, you're going to have to do some planning around what this case is going to take. How much judicial time is a case going to take? And like I say, I'm saying this for judges, special masters, referees, lawyers, irrigators. You need some way to keep a handle on a particular portion of the case. One of the things that we have been working with is an accountability program. I think what courts need to do when they're faced with this type of a complex situation, they need to bring the parties together and say, okay, what's our mission statement? What are we trying to do here? We're not out to save the world from hunger. Let's be specific. Specifically, we can say, we want to adjudicate Indian reserve rights, or Phase 3 irrigators' rights. And at the end of the day, we want adjudication permits issued to these people who prove up. I can best sum this up by saying, if I, when talking about this kind of a program, if I want my carpets cleaned and I hire somebody to come in and clean my carpets, and I say, clean my carpets, I'm going to work, I'll be back at 5 o'clock. And as I get back home, these guys are wrapping up their hoses, and the foreman comes up to me and says, "Oh boy," he said, "we spent 8 hours in here on your house. We used the best equipment. These technicians are the best trained. We use some of the best chemicals that are environmental friendly. But I look down there and I see, but that spot is still on my rug." So what were they telling me? They were telling me about outputs, not outcomes. And I think when you enter into this type of complex litigation, you need to have a way to define what those outcomes are, what the outputs are needed to get to that particular outcome, and you need a yardstick. What's the metrics that we use to see if we're making any progress? Why is that useful? It's useful because if you have to explain to the governor, or the legislatures, this comes in very handy. Simply because the fact when you go and ask for an appropriation before the legislative body that handles the money, they say, well, what's going on in the Bighorn case? You say, well, we had 45 hearings last year. We had 35 witnesses come in and testify. We had 16 new petitions filed. That's not outcome. That's output. So when the state senator who controls the appropriation committee says, well, did you adjudicate any permits? What are you going to say? So with this kind of a program, I think would be very useful in trying to decide and formulate a way to manage complex litigation. And overriding all of this, and I want to stress this because I think it's a very important point, and that is you can't forget about due process. You can't forget about notification. In the Bighorn case, we struggled with that. What is adequate notification to a party? Is publication in the newspaper of general circulation sufficient? Do you need to send a letter to that particular irrigator or that particular party? Those were some issues that we struggled with when we were trying to resolve the Bighorn case. Well, I think a second thing is that's a takeaway here, and that is communication. And that's been touched on here. You know, I grew up in Wyoming. I've lived here practically all my life. And I've come to learn, and I'm not the brightest one in this boat here, I've come to learn that relationships in Wyoming are how you get things done. And I think that's pretty much true probably of the western states. You have to have the ability to talk to people, and on that basis, then you can start to get some things done. Certainly, when we ordered settlement conferences in the Bighorn case, things began to move. At one point, I asked that the lawyers not participate. That raised a great hue and cry. They wanted to be present. But at that particular point, I had a belief that it was the attorneys that were perpetuating this particular piece of litigation. So when the technical people, the irrigators, those kind of folks sat down and started looking at the problems, we began to make some progress. Why is that? Well, I think one thing. We as lawyers are trained to be reactive. What do I mean by that? I simply mean that if a suit gets filed and a client walks into your office, I've just been sued. The lawyer reacts to that and says, oh, here's what we've got to do. We've got to get an answer in the next 10 days. Then we'll file some motions for discovery. We'll take some interrogatories. We'll do this. We'll do that. It's difficult for lawyers to get into the other mode of being proactive. More about that in just a minute. But certainly I think that with this communication between the parties, progress will be made in your case. Joint inspections, going out on the ground together and looking at the field, looking at the source, determining where these things occur, then progress starts to be made. I think another portion that's a takeaway from this is the fact that there needs to be some transparency. And I shudder when I start looking at what we did not do in the Bighorn case. How was anybody supposed to find out what was going on with this particular court proceedings? We didn't have a website. We weren't running things in the newspaper other than those necessary notification ads to let people know what we were doing. Legislature didn't know what we were doing. I would go down and I'd ask for X number of $1,000s to continue the court administration part. The state engineer's office would also go into that same body, not at the same time, and ask for money so they could continue. The Attorney General's office did the same thing. Legislature didn't know what was going on. When they asked me, well, how much longer is this going to go? I can remember saying at least on 2 occasions, well, about 5 years. And I wouldn't want to tell you how far back in the distant past that occurred. So transparency, I think, is something that we need to strive for when we start looking at how do we handle a complex case like general stream adjudication. What can you do to make that more transparent? Not just to the legislature, not just to the governor, not just to the parties, but to anybody who might be interested. There should be a way, and we have the technology to do that, to create a website, to have the ability that suddenly says, oh, I heard about the Bighorn River adjudication. They can Google it, and guess what? Up comes a calendar, up comes all the filings, all the orders, all of those things are found on one site. Here's the next scheduled hearing, 2 weeks off, and it's going to be on Walton rights, or whatever it might be. That air of transparency needs to be present in these kinds of cases for the good of the public, certainly. I also think, as a takeaway, that certainty is something that's very, very vital. When this case got started, people had a lot of paper rights. People didn't know what kind of water rights they had. As I think, as you heard, this case actually got started in '77 because the city of Riverton was having some difficulty with some bonding issues. That's why they asked the legislature to kick this thing off, which they did. Now we know, if you are an irrigator, if you are an irrigation district, if you are the tribes, you know what that water right is. It's down, it's been adjudicated by the court, it's got the stamp of approval on it, and certainly that's very beneficial when it comes to looking at other interstate interest, which may say, well, Wyoming, you're not using all the water in the Bighorn River. We've got it documented. We can show exactly what we're using, exactly what's being used. So the certainty is certainly something that I think is very, very vital and needs to be a part of any of these kinds of cases. Well, those are the 4 takeaways that I would give to you. But I guess what I would also suggest is, and it's a question, where do we go from here? Well, the Bighorn case is technically done. The final decree has been signed. But as you heard, I'm not sure that everything has been resolved. Certainly, we've had the impetus through the graciousness of the tribes, the law school, to put on this symposium. You've got a lot of inertia going right now. Don't let this thing drop. Keep it moving. Keep that dialogue going so that you have a forum, an informal forum, to resolve some of these ongoing disputes which are still occurring and will occur in the future. I think that this is something that could be very, very useful. We've heard a lot of comments and a lot of discussion just in the short time I was here last night and this morning. I think it's relevant because we need to have a forum where the parties and no exclusions can be brought to the table to have some discussions. You know, I need to know who you are. You need to know who I am and what I stand for. When we cover that ground, that builds that bond, that relationship. Then, and only then, can we start talking about some real issues and making some progress. So please, I implore you, don't drop the ball. Keep this dialogue open. Find a mechanism where this dialogue can continue to occur. And maybe, just maybe the law school will step up and say, hey, we're a good facilitator. We might be able to do this. Not only does it present them as neutral, but it also has the ability to bring the necessary people together to start talking about where do we go from here? How do we resolve some of these other issues that were not resolved from the court? Certainly, as I said, I think the jurisdiction of the court is now very, very limited. And certainly, the door's not closed. But hopefully, you won't have to go back and ask the court for a dispute resolution on some particular issue, when you could have maybe solved that if you'd had some dialogue. So, in closing, I thank you for the opportunity to be here to address you. This has been an awesome symposium. I thank you, and good luck.
Okay, you'll all be happy to hear that my role in this is just as short as my role was on the first day, yesterday. But a few important items for everybody who has been here, and you can pass on to others to let you know about what's happening next. There will be a symposium issue published by our law review, and I think some of the law review staff they are here and they've been introduced already. That symposium issue, and I want to just tell you quickly who's going to be publishing in it. The introductory article will be by Charles Wilkinson, whom many of you know. He was sorry that he couldn't be with us, but he said, yes, I would love to write an introduction. Ramsey Kropf and Jason Robison will co-author an article. John Thorson, I don't know where he is now, but we're delighted that John agreed to write for us also. Bighorn Regional Overview. Anne McKinnon, we also talked Anne into writing, and I think she's here somewhere. She'll be writing about post-Bighorn 2 water issues. And then Burke Griggs, whom I met today for the first time, will also write about regional issues from the Bighorn. Larry McDonald, I'm looking straight at Larry. Larry also is going to write a critique of general stream adjudications. You heard him talk about that a little bit today. And Michelle Bryan, whom I also met today for the first time, will talk about post-adjudication water governance, which will be really interesting issues for us. And then finally, somebody else who couldn't be here with us today but wanted to be, and many of you will know him, especially those of you from this area, and that's Jeff O'Gara. And you may also know that Jeff wrote a book called What You See in Clear Water about the Wind River Reservation and in particular the water issues. So it should be a pretty interesting piece that he'll write kind of in hindsight and kind of with a prospective view. Where'd we come from, how'd it go, where are we going now? And he just has a great way of sort of distilling things. And he's not a lawyer, so that might be a nice closing for the journal. Okay, so that's one thing. All of those articles will be published, will be digitally available on the website. That won't happen until, where's our editors, till spring sometime? Next summer? Yeah, okay. All right, but they'll be there. You can find them. You know where our website is and the Law Review's website. There will be a digital recording of the entire symposium, beginning yesterday, all through today, also on the website, the UW website. Additional program materials will be posted there, so the PowerPoints, for instance, that you saw, and some of them were a little difficult to read, you'll be able to read them on the website. The scanned decree that was signed last week, Jason mentioned that earlier, it will also be on the website. PDF, I assume, that you can download. And then I am definitely socially media challenged, so Christine can correct me if I'm wrong, but the law school has a Facebook page, and Christine is going to post a bunch of pictures there and maybe some other things too. So visit our Facebook page and take a look. Okay, now my last task is to introduce Dean Jacqueline Bridgman. She's interim dean of the law school. She's been on the law faculty for a number of years. You won't believe what she had to go through to be here today. She wanted to be with us yesterday, but she has some very high-placed constituencies in this case, or in the state, and in this case, including the State Judiciary Committee. And they had her tied up, although maybe that's not a good word, all day yesterday and last night, but she did make it to join us today. Jacqueline has been extremely supportive of this symposium all along, even though she didn't have as much time to spend with us as she wanted to. And I'm glad Judge Hartman broke the news that Jason and I are going to be talking to you about a continued role of the Law Review in dialogue over the post-Bighorn adjudication decree. So with that, I will give the podium to Jacqueline Bridgman. And thank you all again very much for coming. Oh, and by the way, the committee members, steering committee members, we're going to meet just for a couple of minutes after Jacqueline's remarks in that corner of the room. And I'm indoors, so I'm not sure. Is that northwest corner? Whatever. Thank you again very much.
Good afternoon. I know it's getting late and it's a Friday, so I'll be very brief. But I did want to, although it's at the end of the program, welcome everyone here. I wish I could have done it when all the seats were filled, because I think this is a great program. And I was so glad to see so many folks here. When Professor Robison, or Jason as I tend to think of you, brought this idea to me last year, I will admit I was quite skeptical about it, but as you know, he's enthusiastic, he's passionate, and very dedicated, and it didn't take him very long to not only get me to agree to let this event happen, but to get me excited about it as well. And so, as many of you know, the University of Wyoming College of Law has a long and rich tradition and excellence in natural resources, particularly water law and related issues. And I am so glad that we have Jason and others who will continue that tradition going forward. I think it's an important one. I think having the chance to come together and have these kinds of dialogues is also very important. As Deb mentioned, I spent a lot of quality time with members of the legislature and our Board of Trustees yesterday. Don't tell them I would have rather been here at the conference. But one of the things we talked about is how important it is for us to do this work. And so, Judge, I'm very happy for us to do this sort of thing going forward. I hope this will be the beginning of more programming like this, because I think it exemplifies what we're trying to do, not just with the College of Law, but with our natural resource program in particular going forward. So as we've talked about, first and foremost, we want to be a forum for not just a place where people talk at each other, but where you can really have meaningful dialogue about these important kinds of events. We want the kinds of things we do to be interdisciplinary, and one of the great things about this program, and that I was very happy with, is the fact that it involves 13 different units from around the university. They pitched in time, they pitched in money, they pitched in support, they brought their students here, and I think we're going to build a much better program if we all do it together. So I was very happy to see that. And this also exemplifies partnerships that we can make with folks around the state and within our community, and sometimes people we haven't made partnerships with before. So in the rest of my remarks, I'd like to thank a whole lot of people, and I'd like to start with the Eastern Shoshone and Northern Arapaho tribes. As they were putting this program together, the other thing I was a little skeptical about is when Jason came to me and said he wanted to hold it in Riverton and he wanted to hold it on the reservation. And that skepticism largely came from, you know, it's hard enough for us to put on events in Laramie. How are we going to move it up to Riverton and get it done? But I was up here about 4 or 5 months ago in this very room, actually listening to tribal elders from the tribes talking about a range of issues. And I was so impressed with the hospitality that we received, with the wisdom that was imparted, with the way that people spoke to us, and at least for that day made us a part of the community. I went back after that and told Jason, absolutely, I think we should have it up here. I think that's a very good idea. And having been here for a little bit today, hearing what I've had, I am very, very glad we did that. I'd like to extend our thanks to both of the tribes for once again welcoming me, welcoming us, and I hope this will be the beginning of us to have continued engagement and partnerships going forward, because I think that's really important. I would also like to thank the Wind River Hotel and Casino for their hospitality and for helping us with reservations and catering and transportation from the airport and all the wonderful things that you did, and in particular Cheryl Merrill, I've heard has just been wonderful to work with and very helpful. So I'd like to thank her. I'd like to thank all those sponsors that I mentioned, those 13 groups. They're listed on the back of your program, and I won't go into all of them, but they have also been great partners for us, and we are very happy to have been able to put on this program with them. Our speakers and panelists who have come from several different states in Washington, D.C., and it's not usually easy to get to Wyoming, and especially not the middle part of Wyoming, so we are very grateful to have all of them. And most of them, you know, we don't pay big sums of money either at the College of Law, so it was great to have them come and spend their time and their expertise. All of you who came, I heard we had around 200 people over the course of the symposium. The other thing I was a little worried about is, are we even going to get anybody to come if we hold it up here? And people certainly came in droves, and that has been wonderful. It was a bit out of our comfort zone to come out here, but I think we will be stepping out of our comfort zone quite a bit more as we go forward, because this has worked out so well. So thank you all for coming. I'd also like to thank the members of our College of Law staff who helped put this event together. We are a small law school, and we have a small staff, and we ask them to do all kinds of work all the time. Tanya Anderley, who wasn't here, but helped with a lot of the logistics. Kelly Kruger, who's sitting there in the back, wave your hand, who has done all the money and making sure our bills are paid and all the travel arrangements went well and all of those things. And last but not least, Christine Michael, who you've seen, she was just up here. Christine does just phenomenal work for us. She did our Summer Trial Institute a couple of weeks ago. She put this event on. She was helping me in the wee hours of the morning on Wednesday to do stuff for my meetings yesterday while she was up here. She does a phenomenal job. Christine, I hope I will not see you in the office in the next couple of weeks, and you'll finally be on that vacation you so richly deserve. But thank you so much for all of your work. I would also like to thank Amy McClure, who's the academic coordinator at UW's Outreach School in their West Central region. I've heard has been a fantastic partner with us and very helpful. And then, of course, last but not least, I would like to thank the 10 individuals on the steering committee. Jason has been in communication with me over the course of the last year, which is how long it took those folks to plan this event. And it's just been phenomenal. So Gary Collins, and if you're here and want to stand up and wave, that'd be great. Thank you. The Tribal Liaison for the Northern Arapaho Tribe. Mitch Conteneur, who I think is still in DC, is that correct? He's a Joint Tribal Water Engineer. Deb Donahue, who I know you all know, she was just up here speaking, but she's been a cornerstone of our natural resource faculty for many, many years. And we're so happy to have her. Sam Kalin is also an important member of our natural resource faculty. And so was Sam up here earlier? Did he not make it? But I know he does quite a bit of work, even when you don't see him. Ramsey Kropp, the special master for the Big Horn General Stream Adjudication. Larry McDonald, who I know is adjunct faculty at CU, but we still claim him as one of our own because he was on Wyoming's faculty for quite a while and brought Jason Robison to our attention. So Larry did a great job replacing yourself when you retired, so thank you. Anne McKinnon, who is a journalist, attorney, and an adjunct in the UW Haub School. Is Anne here? Anne's here. Hi, Anne. Yes, we were just speaking earlier. Nancy McCann, the Big Horn Adjudication Manager, and who's also on the Wyoming State Board of Control. She is. Sara Robison. Sara here? I don't see Sara. A member and former tribal liaison of the Eastern Shoshone Tribe. And then, of course, our man of the hour, Jason Robison, who has done a fantastic job. Jason just became a permanent member of our faculty this year, so he actually started putting this together and didn't even know if he was going to have a job by the time it went through. Obviously, we were very happy to have him join our faculty. He has done a fantastic job. I'm not generally don't consider myself a natural resource person, but by the time we're through, Jason's going to make me one. His enthusiasm's so great. He's done a fantastic job teaching his classes, getting our students excited about this area a lot, and so I hope you'll join me in giving him a round of applause for doing such great work. And so with that, I would like to thank you all for coming and being a part of this. Look for other events like this from the College of Law, because as we said, this is just the beginning, and have a good rest of your weekend. Take care.